very far one. 이제 곧 행사를 시작하겠습니다.
Ladies and gentlemen, we will begin shortly. Please take your seats.
Today's session soon, so please be seated. 네, 안녕하십니까? R2P와 북한
Good day, ladies and gentlemen. Welcome to the second day of International Conference marking the 20th anniversary of R2P.
second day of the 2025 International Conference on R2P and North Korean Human Rights. 통역 장비를 확인해 주십시오. 1번 채널은 한국어, 2번 채널
Simultaneous interpretation will be provided throughout the program. Korean is channel 1, English is channel 2. Both languages will be used, so please use the receivers on the tables.
Please check up your interpretation devices now. Channel 1 is Korean and channel 2 is English. All sessions and presentations today will be conducted in both Korean and English. So if you need interpretation devices, please turn on your device on and make sure it is working properly. Channel 1 is Korean and channel 2 is English. 그래서 지금부터는 제가 떠나고
Let us now begin day 2. We will have Hana to moderate the session in English.
Thank you, everyone. Good morning. As a short self-introduction before presenting today's program, my name is Hannah Winninger. I am currently working as an intern at PSCORE while finishing my master's degree. General Secretary Bada and I will be your MCs for today's event. The program for the day consists of a keynote speech from Ambassador Müller, Ambassador of Slovenia to South Korea. Session 5, which will discuss recent developments in North Korean human rights, and Session 6, themed Applying R2P to Crimes Against Humanity in North Korea. Finally, we will finish the day off with a closing ceremony. So let's begin with a warm applause to welcome Ambassador Müller to the stage.
Okay. So I'll start again. But I think that you heard my greetings. So for me, it's a privilege to stand here today among friends and colleagues who share a deep commitment to human dignity and justice. For Slovenia, a small nation that emerged from its own struggles for freedom and independence, it is especially meaningful to speak about one of the gravest human rights crises of our time, the situation in the Democratic People's Republic of Korea, or North Korea. When we discuss North Korea, we're not merely addressing geopolitics or security concerns. What we are addressing are the people, millions of men, women, and children whose most basic human rights are denied, whose voices are silenced, and whose suffering demands our attention. Reports from the United Nations, civil society, and the testimonies of courageous defectors reveal the same harrowing reality: a society where repression is systemic and fear is a daily companion. Political prison camps hold tens of thousands in inhumane conditions. Guilt by association means entire families are punished for the alleged actions of one person. Freedoms of speech, religion, and movement do not exist, and food insecurity remains severe, not because of lack of resources, but because state policy prioritizes weapons and privilege for the few over survival of the many. The United Nations Commission of Inquiry has concluded that these are not isolated incidents, but actually crimes against humanity, deliberate, systematic, and ongoing. I think in 2005, the international community embraced a principle that speaks directly to the case of North Korea, the responsibility to protect. From my point of view, it rests on three pillars. Every state has the responsibility to protect its people from genocide, war crimes, ethnic cleansing, and crimes against humanity. The international community has a duty to assist states in fulfilling that responsibility. And when a state fails, or itself becomes a perpetrator, the international community has the obligation to act. North Korea is such a case. The regime does not simply fail its people, it systematically violates their rights. And the world cannot remain silent. But let me be clear. Action under R2P does not mean rushing to a military solution. From my point of view, it basically means sustained scrutiny at the United Nations, including the renewal of the Special Rapporteur's mandate, strengthened accountability mechanisms, including referral to the International Criminal Court, targeted sanctions focused on perpetrators and not on ordinary citizens, humanitarian aid that directly reaches people in need, and unwavering support for defectors and survivors, whose testimonies shine a light where the regime tries to cast darkness. Slovenia, although we are very small, is steadfast in its commitment to the protection of human rights. Our own history reminds us that freedom is fragile and that peace depends on justice. As a member of the European Union and United Nations, Slovenia supports all resolutions and mechanisms that hold North Korea accountable. We insist that human rights are inseparable from peace and security, and we affirm that crimes against humanity must never be shielded by claims of sovereignty. We may be small, but our voice will not be silent. Allow me also to express Slovenia's deep respect for our Korean hosts. For the Korean people, this issue is not only about universal human rights. It is about peace, it is about security, and about the long and difficult road that separates families and the nation. Slovenia recognizes that South Korea carries a special moral weight in this discussion. And the leadership of South Korea has ensured that the suffering of North Koreans is not forgotten on the international stage. And Slovenia stands in solidarity with South Korea. In your pursuit of peace, in your commitment to justice, and in your resolve never to let the plight of your northern brothers and sisters fade into silence. So, allow me to be a bit hypothetical. What must be done? From my point of view, first, we must maintain international unity. Division among international community only strengthens repressions. Second, we must strengthen accountability mechanisms so that perpetrators know that the world is watching them. Third, we must expand humanitarian channels, ensuring aid goes to the people, not to the regime. Fourth, we must support defectors and survivors, protecting them and amplifying their voices. And finally, we must uphold the responsibility to protect, not only in principle, but also in practice. Silence cannot be our response to crimes against humanity, and conferences like today's are a perfect example. The people of North Korea cannot speak freely, but their silence is not consent, it's fear. Their suffering is not invisible, it is documented. And their future is not predetermined. It depends on whether we, the international community, choose action over indifference. I can say that Slovenia will continue to lend its voice to those who cannot speak. We will stand with our Korean partners, with our allies in the United Nations, and with all who affirm that human dignity must never be negotiable. The responsibility to protect is not only a doctrine, it's a duty. And wherever we are, human dignity must always prevail. Thank you.
Thank you, Ambassador Müller, for this opening speech and for sharing your insights. We will proceed with session 5, which will be discussing recent developments in North Korean human rights. While the staff of the venue is going to set up the tables, please take a look at the posters we have around here. It's a survey for event satisfaction, so those of you who attended yesterday can already scan the QR code and fill out the survey. We would appreciate the support. Also, as a reminder to all panelists, if you have PowerPoint slides prepared, please come up to the podium I'm standing at in order to present. But if you do not have PowerPoint slides prepared, please just stay seated while you hold your presentation. Another note to all panelists for the upcoming session, please make sure to actually speak into the microphones as it makes the work for our translators easier. Please, everyone for session 5, make your way up to the stage. Dear audiences, please settle again. We are ready to begin with session 5. This session will be hosted by Elonor Fernandez, a human rights officer with the UN Human Rights Office here in Seoul. Thank you very much.
안녕하십니까, 여러분. My name is Elonor Fernandez. I work here for the UN Human Rights Office. Thank you very much, first of all, to the organizers for organizing such an important conference and for bringing so many experts from the region to keep the DPRK human rights situation firmly on the agenda and to learn from each other how to mobilize support. So as mentioned yesterday, the High Commissioner issued a report at the beginning of September looking at the last 10 years in the DPRK. So the office here in Seoul is mandated to monitor and collect information regarding the human rights situation in the DPRK, but also to establish a repository of information for future accountability purposes. So this is something that I just wanted to mention today as we're talking about accountability. The office here has a repository, which is a database where we collect information that will be used one day in either judicial or non-judicial accountability mechanism. As said briefly yesterday, the High Commissioner report reviewed the human rights situation and concluded that the situation has not improved and in many respects has even deteriorated. Our recent findings show the introductions of new laws, policies and practices that impose tighter surveillance and control over all aspects of life. Political prison camps remain in operation. The fate of thousands of disappeared persons is still unknown. The right to food continues to be violated, and some states' policies are worsening hunger. The death penalty is more widely permitted, and freedom of expression and access to information have significantly regressed. Some of these issues we are going to be talking about right now with the esteemed panelists. I will first hand over to Mr. Sang-Yong. He is the director of Daily NK, an online news outlet that focuses on reporting on the DPRK, society, politics, and economy, and human rights, using information gathered from inside the DPRK and along the Sino-North Korean border. He will be talking about forced labor and how it's institutionalized. This is also what we have been reporting to the Human Rights Council and also on other reports that we have. And he will be speaking specifically on the overseas forced labor. Mr. Young.
네, 안녕하십니까.
Good day, ladies and gentlemen. As introduced, I am Lee Sang-Yong, and I'm from Daily NK. Daily NK, I'm not sure whether you're all aware, but we do have informants in North Korea. And what we do is deliver the information provided by them to the international community. It's been already 20 years since our establishment. So, of course, there were so many reports and articles that were written, and we've been sourcing the data from North Korea, and we have been delivering that to the international community to make sure that we can show the current status, the reality of North Korea, and to find a way to devise desirable policies. So that's the purpose of the organization. Today, I would like to talk about the forced labor realities of North Korean workers that currently work at seafood processing plants in China. I'm not sure whether you do know, but to have North Korean workers in China in the seafood processing plants, this may seem unfamiliar, and I'm not exactly sure whether there are many people that thought about the working conditions of North Korean workers there. But we do have a report on this very issue. So based on trade-related statistics and by interviews with workers and managers there, we do want to highlight the issues and also the aspect of accountability. I also was in China for around 3 years. I was a correspondent in China, and as you all know, it wasn't exactly in the form of a correspondent, but my status was the status of a student, an overseas student. And I did see for myself the situations of North Korean workers in China. And of course, I was a student in disguise, but I thought if I had to work under certain such conditions, it would have been so frustrating and so disturbing. So I hope that you can actually listen to this presentation as if you were in their shoes. So this report is on DKNK's website, in the AND Center website. So this has to do with the forced labor among North Korean workers in China, and we really wanted to raise this issue. So we've interviewed 30 workers, so workers that worked in China, or those that have came back, or those that were dispatched again to China. So they were interviewed, and there were a total of 8 managers of both the North and China that were investigated and interviewed. And there are 11 indicators of forced labor by the ILO. And based on these indicators, we have analyzed their working condition and working environment. So please refer to the report when you do have the time. And with regard to forced labor, I do want to emphasize this issue because forced labor has to do with physical and labor intensity. North Korean workers had to work 12 to 17 hours per day, and they had to work overtime, and they were exposed to severe labor. Basically, they had to work 7 days a week. And if you think about, well, any holidays, excluding New Year's or Thanksgiving, there were basically no holidays. There were specific factories where they had to work standing labor from 5 a.m. to 10 p.m. and meals only for 15 minutes. There were cases where workers collapsed from exhaustion or heat stroke, but they were forced back to work. And all of these, of course, trigger the indicators of forced labor by the ILO. And as you all know, freedom and surveillance was also another issue. I'm sure that you all know this. In 2020, DPRK has introduced this law that has to do with the restriction of freedom and surveillance, and this applies to those that work overseas. So the point that they are employed, their passports are confiscated, and there's restriction of movement upon entry, and there are political security agents and guards on site to keep strict surveillance over the workers, so they cannot move, they cannot leave, which of course they ban all cell phones, no outside contacts, and some workers also testified that it would go so far as to monitoring who laughed in the workers' dormitories. So it's basically a jail, not only in the north, but here also in China, where these forced laborers were basically confined to. And there's also the issue of wage exploitation. We were able to once again reaffirm this critical issue. Minimum wage is around 550,000 won, or 3,000 yen, but what the workers actually receive is just 100 to 800 yen. And the remainder of the wages are transferred to the DPRK government, and it's used for their management's sake. And workers, not in monetary terms, but there were also cases where they were paid in kind, such as rice, clothing, and soap. There were certain workers that worked 3 months. I mean, I mentioned about 12, 17 hours of work, but they received only 600 yen for the 3 months of work. So all in all, they're not being paid for their labor. They're basically just slaves of the modern society. There's also psychological oppression, and this was once again reaffirmed. Every week they have to go through mandatory political education, they are loyalty pledges, and they are a part of really worshipping the DPRK government. And they also do say that there are internal spies, their colleagues, internal spies that keep them on check. And if there are any minor complaints, they would be punished. For those that try to escape, they would be repatriated. And if they are repatriated, basically it means that their political life is over. And naturally, in China, this working condition and the working environment is about oppression, it's about fear. And the workers have to refrain from anything. And you can see that they're keeping themselves on check, basically. So they say that even stares could be grounds for punishment and repatriation. So such political oppression, psychological oppression, exploitation, all of this combined indicates the severe violation of human rights of these workers. And there's of course many female workers in the processing factories of China. And in the case of the female workers, sexual exploitation has been quite significant. This is basically in violation and harming human dignity, not only during working hours, but other than that, there is no safe space for female workers. We do see senior officials, DPRK officials, factory managers that basically harass female workers sexually. And in these dormitories, they live together, so they would be called upon by senior officials. And there are cases where through coerced sexual favors, if they spend some time with the senior workers, they may end up with lighter work, for instance. And during COVID-19, there is a specific target, specific dollar amount that they had to earn. But because of COVID-19, the factories had to close down. So what happened was there was also testimony that a female worker had to engage in forced prostitution to actually meet the monetary target. So you can see that this is a sexual exploitation, a systematic sexual exploitation run by the government. We do want to mention that there is this disparity with international norms. North Korea hasn't ratified the ILO Forced Labor Convention. China did ratify, but it has failed to follow through. And in line with the UNSC resolution, forced labor and sending laborers to China is prohibited. However, we're seeing strengthened collaboration between the North and China, and we're seeing more laborers and workers being sent to China. And their status is not as a worker or labor. It's basically they have been disguised as different status, whether it be student or whether it be, let's say, OJT interns. So we can say that this is in strict violation of the UNSC resolutions. And this report specifically has to do with the voices, the pain, the suffering, and the sexual exploitation of female workers, and we were able to see for ourselves how devastating the situation is. But the reason why all of these records and these documentation is possible is because for a number of years there was that will to actually compile the truth, the facts. There was this will and determination, and I think that this struggle has enabled us to let this be known. So to make sure that the victims are not alone, your solidarity, we do hope and we do believe that will be the beacon of light going forward and having their sufferings be lifted. And I do know that the seafood that's on the table sometimes can be the result of forced labor. So within China, sometimes it's disguised as Korean seafood, and sometimes it would be actually processed by North Korean workers, but then it is labeled as made in China. So, in some sense, we may be those that have been negligent when it comes to forced North Korean labor. So, once again, this has to do with consumer ethics for people around the world. So, I do want to mention that this is an issue that we do need to raise. And this report is not just mere statistics. We do have workers that have testified despite that threat to their life at risk. And the workers said that the reason why they're really voicing out their situation is because the hope that it will help improve someone's life and human rights in the future. And because this courage is there, I think that I'm also here to share this information. So we do have those that are brainwashed, those that are not aware of the fact that this is a violation of their human rights. It's important for us to extend our hand and really have them understand and raise their awareness, and also raise the awareness of the public and the international community. So we have international organizations, government authorities, the media, and everyone here together all do need to join hands. And with that, let me conclude my presentation. Thank you very much.
Thank you very much also for raising the point of thanking escapees and people that are allowed to be interviewed by us or by CSOs, how important it is for all of us to have this type of information, because of the access to the DPRK is, at least for the UN, is not possible, and for some CSOs is also quite difficult. We will now turn to Mr. Jae-Hoon, who will be speaking about the latest findings regarding the implementation of the death penalty in the DPRK. He is a senior manager and DPRK specialist at Amnesty International Korea, where he leads research and documentation on human rights violation. Mr. Choi, please.
안녕하십니까.
Good morning, ladies and gentlemen. I am affiliated with the largest human rights organization in the world, the International Amnesty International. I'm a North Korean specialist at the Korean office. I'd like to talk about the recent patterns of the public executions in North Korea, particularly one that began in the 2020s. It is well known that North Korea is now implementing public executions, but when it comes to the recent trends, I think such information is relatively less known compared to other human rights infringement cases. So I'd like to make public about the information that we have gathered at the Amnesty International in order to fill the vacuum of having no information about the changes in public executions in Korea.
한번 확인해 주시겠습니까?
So please go to the next page.
바로 하도록 하겠습니다.
So let me proceed. I'd like to first talk about the problems associated with public executions. In North Korea, acquiring information about public executions is very difficult. And about the due process, about the implementation procedures, none of such information have been disclosed to outside world since the outbreak of the COVID-19. It is also well known that North Korea has carried out a blockade in the borders, and therefore we only have limited information from the internal informants, and as well as very few those who escaped from North Korea. So the mode of execution is mostly by shooting. The public executions are the main mode of the implementation of the death sentences, and therefore the death penalty by shooting is the most well-known form. And death by hanging is also another form that is used quite frequently. I'd like to say that the public executions inflict indescribable pain and humiliation to those sentenced to death. So I believe that such practices directly contravene international human rights norms, including protection of rights to life and the prohibition of cruel, inhumane, or degrading treatment or punishment. And also, the large numbers of residents, including the children, are forced to watch this grave human rights violations, and this leads to fear and psychological trauma. And the serial killers and the other types of criminals have been sentenced to death, and also those who have committed relatively minor crimes have been sentenced to death. And this is in violation of the freedom, the rights to freedom under Article 6. And some of them have been sentenced to the death penalty because they were exposed to South Korean media. So I really doubt as to whether such sentencing is appropriate. And also the fact that this death sentencing and execution is made a public event is a vivid reminder that the level of human rights perception of North Korean officials is indeed very low. And Amnesty International has documented all this, the implementations of death penalties for many decades. In the 1990s and during the notice, the Amnesty International has made public about such the events and has noted about the grave violations of human rights. We also issue annual reports, and through these annual reports, we have also shown the global trends about the public executions and capital punishment in North Korea and other countries, and call for immediate cessations. And today, through my presentations, I'd like to talk about the past 6 years of interview we have conducted with North Korean escapees. And based on these in-depth interviews, we have done a thorough analysis about the current situation in North Korea. So we are able to compare the public executions characteristics 2010s and the comparing that against the duties to better understand the practices. Let's talk about the research methodology and limitations. We have divided into two groups. And Kim Jong-un is known to have assumed the power following the death of Kim Jong-un in 2011. And we have broken down the period, the recent period that refers from 2011 to 2019 for about 9 years, which is until the outbreak of the COVID-19 pandemic. And we are going to partially deal with the 2020s, and they are rather supplementary compared to what we are going to cover today as the main period. So this will be the recent and past periods I refer to. And we conducted in-depth interviews with 114 North Korean defectors, and we dealt with the overall human rights infringement issues. So we picked 60 interviews, which gave detailed accounts of the public executions out of 114 people. 88% of these respondents escaped North Korea after 2017, and they have eyewitnessed the public executions in North Korea. And I think we have some limitations. There are quite a few to be noted in interpreting the findings. First, research is based on qualitative testimonies from escapees. We have carried out in-depth interviews, and basically our interviews are quite limited when it comes to providing quantitative or statistically representative conclusions, because our interview is based on qualitative testimonies. And I'd like to talk about some of the notable changes in public executions, which are the positive developments observed in the 2010s. I'd like to say that there is a decline in the public executions. If we put together the testimonies from North Korean defectors, they say that they perceived a clear reduction of public executions compared to the past. None reported an increase. And only very few people said that the public execution incidents are pretty much the same. And also there is a change in direct witnessing experiences. In the past, they personally witnessed the public executions. It was quite widespread, but respondents these days say that they had not seen one directly. This is a predominant statement. And the second has to do with differences in narrative detail. In the past, many people detailed recollections of the timing, location, and changes in atmosphere of the executions. But these days, the testimonies are basically based on hearsay evidence. So this is not a direct observation, and therefore they lack detail in the description of these public executions. So this response is suggested that there is a difference in memory, but it also indicates there's a possible reduction in the occurrence or visibility of the public executions themselves. But some of the defectors said that they witnessed or heard credible accounts of sporadic public executions, but the number of the instances have reduced significantly. This is a consistent trend we find among the interviews. However, we need a further inquiry to determine whether this reduction reflects a genuine decrease in executions or the effects of increased secrecy or reduced public visibility. Next, I'd like to talk about the second type of chain, about whether the people are forced to witness the public executions. In the past, everyone had to participate at this event. In the past, it was more like a forced mobilization. But from 2011 to 2019, we find that the mandatory participation is still a must. But even if you don't show up at the public executions, you're not put into disadvantageous position. People said that they did not want to see the public executions, so they chose not to show up at the event. And another interesting point is that children meaning those under 18, are not required to participate at the public events. Those who attend the middle high schools had to participate at the public executions in the past, but not anymore. But we're not able to conclude that this is a nationwide practice. But compared to the past, where every child, those under 19, had to participate in these public execution events, it is not the case anymore in some of the regions where we were able to interview the defectors. And thirdly, I'd like to comment about the changes in the perception of the defectors. In the past, people perceived these public executions to be a must-attend event, a very important state event. But afterwards, more recently, from 2011 to 19, people came to doubt as to whether this type of treatment is appropriate, whether the fact that the authority deals to treat the residents in this manner is appropriate. And therefore, we understand that people have become more critical about the public executions. I think this has to do with the fact that more information is flowing from outside, and therefore more and more people are being exposed to human rights-related discourses compared to the past. So the public execution is not a way to instill fear inside the North Korean residents. And I think there is an issue about the legitimacy and about the cruelty. And I think such critical perception is on the rise in North Korea. And of course, this has to do with the regional differences, and it's very difficult to generalize the perception held by North Korean people. But the role of public executions as a mode of exercising control of the North Korean people, I don't think that's working anymore. And in the 2010s and I don't think it's quite sufficient that we call it enhanced human rights treatment, because we see that there's another trend, which means that undisclosed executions are being definitely on the rise. So we see that the executions do take place, but not as a public event. And those in the detention facilities without public participation, the authorities participate only at the event where the executions are held. Because of this secretive nature, the information is not disclosed to the public, and therefore only the few detainees are able to verify the actual frequency. But the international society community has condemned the cruelty and inhumane nature of the public executions. And in 2013, the UN COI report was issued, and the 2014 landmark report has significantly advanced the global understanding about the scope and gravity of the human rights violations, including public executions. And therefore, beginning in the 2010s, and I believe that the visibility of the death penalty executions have been reduced significantly. And also, there was a change in the mindset of the North Korean residents. And therefore, the public executions do not lead to compliance, but it increasingly, on the other hand, provokes moral discomfort and resentment. And therefore, the authorities had to bear in mind of the resistance that may come up as a result, and therefore the authorities are choosing to selectively execute to carry out the public executions. And I would like to say that there is another issue with non-public executions because it can be more cruel in nature because of its secretive characteristics. For example, they have used the physical force. According to the many defector accounts, at the detention facilities, executions reportedly used metal rods or the blunt weapons to repeatedly strike the heads of death row inmates until they died. And the use of the blunt force causes extreme suffering. It can be regarded as a clear example of torture and cruel. And in many cases, the inmates, the death row inmates, after the executions, the remains have not been handed over to the families. I'd also like to mention that public executions have decreased, but the execution continues to be carried out. It's just that it's just become difficult for outside analysts to acquire information about the execution. It has become non-public, and although it has become more cruel because physical force is now being used as opposed to other modes such as shooting. And now moving on to 2020s, Amnesty International has collected information. And this is quite limited in scope. And we have not acquired any interview where the North Korean defectors has made a testimony that they have eyewitnessed the execution. It doesn't mean that there has been no execution carried out. That is quite not the case. And according to the several escapees who fled after 2020 and have testified, the mode has changed, took another turn. We have indirectly acquired information that public executions may have increased. At another CO, the UN, the office, the conference, there was a special testimony made by North Korean defector. At the from the Hwanghae-namdo, there is a defector that has escaped North Korea in 2023. And this person has said that for 7 years, public executions has been completely disappeared. But after the COVID-19, the number of instances have grown. So beginning in the 2020, it has grown. Daily NK and various North Korean specialist medias have said that they have the testimonies of the public executions being carried out in the 2020s. So this is another turn. However, when it comes to the Amnesty International, it is difficult for us to draw conclusions on the overall trend beginning in 2020s. It is because there has been around 80 to 95% decrease in the number of North Korean escapees who settled in South Korea. So there are only very few North Korean escapees from North Korea who escaped North Korea in 2020s. This is a rapid shrink, and therefore we conducted in-depth interviews with North Korean defectors, but it's less than 10, and which means that the raw data they receive from the North Korean escapees who escaped North Korea after the 2020s is very small. And because the scope is very small, we cannot undermine the quality of the valuable information that they provided. However, still we find it very difficult to verify the validity of the interviews, the contents of the interviews that they provided. So there are limitations. So there is a vacuum about information. But we still believe that there is a trend in the position of the North Korean government. A North Korean authority has maintained a legal stance that this legal stance is quite contrary to the overall declining trend of public executions in North Korea. After 2020, the rights to freedom is known to be greatly infringed upon by the overseas culture, the Anti-Overseas Cultural Inflow Act. And this act has specifically mentioned that they're willing to carry out public executions on very important infringements. And this goes against our position. And the Pyongyang Cultural Language Protection Act of January 2013 is the most strongest form of expressions about imposing penalties for the very serious violations. And what I'd like to say that the formal codification of public executions within the legal framework of the 2020s suggests a regime's unwillingness to abolish practices. And their deliberate intent to institutionalize and preserve as a functional instrument. Of course, they have mentioned it. The cases is extremely rare, but on public executions, this is the first case where the law provides for an official the implementation of the public execution. This is a very important point to consider. Indeed, after the May of 2019, there was a third review of the periodic review and of at the Human Rights Council, and there was a fourth review conducted in November of 2024. And they said that in extremely rare cases, confined to exceptional circumstances, they acknowledged that the public executions may be carried out. So they have given an explanations, and North Korea, when it comes to the rights of freedom, they have publicly denounced, and they said this is like a discrimination or a very critical perception. So I think this is a change in stance. I think to the international community, North Korea is indicating that the public executions may be carried out in the future. This is like a public announcement on the part of the North Korean authorities. Now I'd like to talk about the implications. What implications does this change have on us? And according to the testimonies based on the North Korean defector interviews, if I can sum up conclusions, I believe that the instances have decreased. and the mandatory nature has changed, and the perception of North Korean people has also changed. So one may interpret the situation in a different manner, but overall, I think there is some positive aspect, and I think it means that the show of a strong interest of the international community and also a change in the perception of North Korean people has affected the change. But at the same time, there is a concurrent rise in reports of non-public executions, and the overuse of the capital punishment has not been diminished. The mode of execution has shifted from public to private cities and become more cruel. And circumstances since 2020 make it and it also tells us that they have codified the public executions in their legal framework. And we are also witnessing increases in the public execution incidences. So we can also assume that there is more widespread the public execution in North Korea. So we cannot overall conclude that things have improved in North Korea. I think in some ways the patterns of abuse have been intensified or expanded because there is only limited information we can acquire from North Korea. Monitoring of the international community also has been limited to a significant extent. For someone like myself, I meet with people, the North Korean specialists, and they say that the information access is very limited. And that means that North Korean authorities have become more abusive in North Korea. They can be abusing the situations to infringe further on the human rights. And therefore, the visible the decrease in the number of frequencies of the public executions does not lead to a positive appraisal by itself. I think what we now is that we need to come up with more objective the information. I think we need to collect more information and we need to make public more about the information that we acquire. I also need the international solidarity to strengthen pressure against North Korea in this regard as well.
마지막으로 이제 국제 MSC의 향후 과제.
Before I conclude, I'd like to talk about what the challenges we face and the recommendation that we make. We have continuously recommended North Korea to eliminate public executions. At the Amnesty International, we will continue to monitor implementation of public and non-public executions through multifaceted research methods and supplementary data sources, including in-depth interviews with the victims. We will continue to increase public interest in North Korean situation, and we will continue to urge North Korea to fully suspend and eliminate public executions. Thank you very much for your kind attention.
For this very good presentation. I just would like to highlight also that there has been 6 new laws since 2015 that have been allowing the use of the death penalty, 6 new laws that have been passed. And the office has interviewed people that has witnessed executions for the distribution of unauthorized media, for drug use, for economic crimes, for prostitution, pornography, trafficking, and murder. So most of these crimes are not serious crime. And yes, I invite everyone to read the report of the office once again. Thank you very much. We are now going to turn over Mrs. Kwon Do-Young, the head of the North Korean Human Rights Team at the National Human Rights Commission. She will speak about the DPRK's human rights policy and policy tasks. Mrs. Young, please. Thank you.
존경하는 내외 귀.
Distinguished guests, ladies and gentlemen, and all of our activists from home and abroad, experts working for the human rights situation of North Korea. As introduced, I am Kwon Doyeon, representative of the National Human Rights Commission of Korea, in charge of North Korean human rights. And here, as we commemorate the 20 years of R2P, I would like to talk about the relationship this has with the human rights situation of the North, and also on what the policy implementation tasks are. The R2P adopted at the 2005 UN World Summit represents a new paradigm of rights and responsibilities. It affirms that the state bears the primary responsibility to protect its own population from grave human rights violations, and that the international community has a responsibility to intervene when the state fails to do so. So this is an important transition. It's more than an international norm. It's about not just sovereignty, but responsible sovereignty. So this does play as an important milestone when it comes to protecting the citizens. R2P is about something that goes beyond military intervention to include preventive protection through prevention, early warning, and humanitarian assistance. And in 2009 and 2010, reports, UN Secretary General recommended expanding this R2P beyond, as mentioned, military intervention. And the international community and human rights organizations have focused on building early human rights protection systems grounded in these principles. So making sure that we do have early warning system, expanding humanitarian assistance, and efforts to make sure that human rights are protected in advance are the critical elements when it comes to R2P. The international community has been focused on such prevention, and it has engaged in monitoring of countries at risk. Record keeping and documentation is something that's being all the more emphasized, and such efforts are still being made. So when it comes to North Korean human rights, I would like to now go into what the reality is like right now. In 2014, according to the UN COI report, it indicated state-led crimes against humanity, such as political prison camps, public executions, torture, and forced labor. The report concluded that the North Korean government has completely neglected its responsibility to protect its own population. And not only that, according to the report released by OHCHR, it indicates the seriousness of the issue. And this follow-up report by the UN High Commissioner for Human Rights that was released in September of 2025 indicates that human rights repression in North Korea has intensified over the last decade, ever since the COI report was released, and that there is a systematic human rights violations that are continuing. So we can say that this is a critical element that has to do with Pillar 1 of the state not being in the position to protect their citizens. And consequently, the international community is implementing non-military preventative measures to address North Korean human rights situations, including early warning, documentation of human rights violations, and humanitarian assistance, and strengthen human rights education. And Korea is also actively participating in this endeavor. So then, when it comes to humanitarian assistance and prevention, what kind of legislative framework exists with the Republic of Korea? What's most important has to do with the North Korean Human Rights Act. North Korean Human Rights Act has to do with introducing peace on the Korean Peninsula. It's an overarching type of act, and it also plays the role of a bridge between Korea as well as the international community. And discussions on North Korean Human Rights Act took place in early 2000, and the enactment of North Korean Human Rights Act in the U.S. in 2004 and Japan in 2006, and for Korea, this act was established in 2016. In 2005, it was established, and for 11 years. So discussions began in 2005, and there were 11 years of work, and that led to the North Korean Human Rights Act. And this act clarifies the state's fundamental responsibilities and establishes key institutional mechanisms such as North Korean Human Rights Foundation, North Korean Human Rights Record Center, Advisory Committee on the Promotion of North Korean Human Rights, and the Ambassador for International Cooperation on North Korean Human Rights. In particular, Article 10 of the Act mandates the establishment of the North Korean Human Rights Foundation to conduct investigations on the human rights situation in the North, but due to National Assembly's failure to recommend board members as stipulated under Article 12, the foundation, which is a critical mechanism, has yet to be launched, even 9 years after the law came into force in 2016. This foundation is critical because it's to document the situation of the North and also provide policy recommendations to the government. And not only that, it is also central in terms of the collaboration among stakeholders and relevant organizations. And in terms of protecting victims, we believe that the foundation is critical. So when it comes to improving human rights situations in the North, and in terms of enabling our role as a part of the international community to protect the rights, the foundation of not having this established is a critical barrier. So it's important to make sure that we do have this effective system in place as quickly as possible and enhance collaboration with the international community. And I would now like to talk about R2P and the role of my organization, the National Human Rights Commission of Korea, or NHRCK. We do provide policy recommendations, we monitor and we strengthen collaboration with the international community, and we also continue on to raise agenda items on human rights. And also with regard to recommending members of the foundation, 4 times, via 4 occasions, we have asked the National Assembly to follow suit on the act. So we engage in monitoring North Korean related issues, we provide feedback and we seek feedback, and we actively engage ourselves in promoting human rights. Not only that, the Human Rights Commission also provides education and raises awareness, and it basically very much focuses on preventative activities that's indicated in R2P. So in order to enhance human rights in the North, we also play a critical role in enhancing the collaboration among stakeholders. And I believe that this, of course, has to do with prevention as well as response out of the 3 phases. So this basically is the effective effort that is made when it comes to R2P. So the Human Rights Commission of Korea, based on the R2P principles, is focused on the country's obligation to protect their citizens and also focus on prevention with the international community and humanitarian response. So the Commission plays a critical role, and we will continue on to engage in active participation with regard to these issues. North Korean human rights issues is a core matter, not only for the Korean Peninsula, for the international community. We need to find a way to minimize the damage and the harm, and the Korean government needs to put in place the right legislative framework and engage in international collaboration to make sure that the R2P Foundation is in place firmly and surely. One single human rights issue of one specific region, it is not confined to that region. It is a matter that impacts everyone around the world. And according to the Constitution, Article 3, North Korean citizens are noted as the citizens of Korea. And escapees are scattered across the world, and especially for those that reside in China, their rights protection is a major matter that has been mentioned. If they are forcibly repatriated, there are, of course, undescribable human rights violations that would take place. So, of course, the country has the obligation to protect, but if they cannot uphold their obligation, the international community has that role to play on behalf of the state. And we have UN and regional organizations that have that second obligation. And the Republic of Korea needs to introduce measures that will enable this to be possible. And North Korea is also has a very special relationship with the Republic of Korea. And once again, under our constitution, North Korean citizens are noted as citizens of the Republic of Korea. So with the international community, we do need to pay further interest into the human rights issue. Thank you very much.
Thank you, Mrs. Kwon, for highlighting the work of the National Human Rights Commission and the ROK regarding North Korea. I will now turn to Mr. Chang Se-Yul, He is originally from the DPRK and the current leader of the North Korean People's Liberation Front. This is a Seoul-based organization composed primarily of former North Korean military personnel. He will talk about the recent challenges in the North Korean residents' perception of human rights. Mr. Chan, please.
My name is Se-Yul, and I'm a North Korea defector myself. I would like to first begin by extending my appreciation to Mr. Kim Tae-Hoon and the organizers at the PSCORE for preparing this splendid event. I'd like to say that there are three core pillars to R2P, which would be the primary responsibility to state for protection, the responsibility of the international community to assist, and the responsibility of the international community to take action. At the UN Commissions of Inquiry on the Human Rights Situation DPRK, they concluded that North Korea has committed crimes against humanity, and that there should be adequate responses to their crimes. But 10 years have passed already. The North Korean residents continue to be exposed to systematic violence, including political prison camps, public executions, and torture. And the data that I use is from the second half of 2025. From July to August, we collected information through informal in-country networks and defector-led channels. Currently, along the borders, we have operated contact networks. The defectors maintain contact networks. They consist of family, relatives, acquaintances. And also we keep in touch with North Korean escapees and victims of trafficking who reside in North Korea. Who reside in China, excuse me. And also there are informal testimonies conducted from the networks we have with North Korean overseas workers and deployed the military personnel. The information network provides real-time indications of social dynamics within North Korea, and they serve as the only civilian-based data sources capable of comprehensively analyzing the residents' human rights awareness as well as the ongoing intensification of rule by fear. I'd like to talk about the North Korean situation. I think there's an intensification of fear-based governance and the expansion of control-based mechanisms. Most importantly, there is an expanded enforcement of the law on rejection of reactionary ideology and culture. The North Korean authorities, since 2024, have classified activities such as watching Korean media content, communicating with South Korean nationals, and sending remittances abroad as anti-state crimes. They strengthened punitive measures, including family-based punishment, forced expulsion, and detention of re-education camps. Residents with family members in South Korea as well as relatives of North Korean escapees in China have been designated primary surveillance targets. And multiple testimonies indicated more than 60% of North Koreans forcibly repatriated from China in since October 2023 have disappeared into political prison camps. And at our organizations, we have a list of 194 people who disappeared. 151 have been identified through their photos. And it's quite convenient for us these days compared to the past to call people in North Korea, so we can easily identify the people if we made sufficient efforts. Now, North Korean the authorities operate a digital surveillance system that tracks residents' phone communications, geolocation, and mobility in real time. In addition, the Chinese authorities actively employ AI-based facial recognition systems to track North Korean escapees. Even if they hold the temporary resident permits, the escapees are closely monitored by the Chinese authorities. On the collapse of the economic freedom and internalization of human rights awareness, I'd like to say that there's a reported decline in remittances. And in the past, North Koreans have remitted cash to North Korea and their relatives in North Korea. But in 2024, our organizations believe that there is a visible decrease in the remittances. This is not because of deteriorated financial situation of North Korean SKPs in the south. It is because the exercise of control has been much strengthened compared to the past. For the past 10 years, at our organization, at the Hamgyong Buk province, North Hamgyong province, I don't want to identify this location. There is a family member who was associated with cash remittances, and he was detained by the authorities, and he died subsequently after being held detained by the authorities for some time. I would like to express my condolences to this individual who have suffered significantly by the state security officials and died subsequently. And I also like to report on the reduced autonomy of the marketplaces, which is known as 장마당. And according to the non-socialist, because of this group members that promote the socialist activities, they have been limited of their activities, the market activities, because of strengthened crackdowns on illegal trading. And according to the relatives of North Korean SKPs, people tend to not respect the public the announcements made by the authorities. I escaped North Korea in 2008, and I remember that I called my internal informants, and very few of them criticized openly about Kim Jong-il, the father of the Kim Jong-un, the leader. And when we criticized Kim Jong-il, they said that we should not making such harsh comments. But these days it's quite different. If we talk to internal informants, they will be more critical about Kim Jong-un. I think that's a change. And also there's a change in the military. I believe that there have been quite a few military, the soldiers and military officers that have been dispatched to Ukraine, the Russia-Ukraine front. And they die because not because they want to protect their homeland, but they die because they are fearful about Kim Jong-un. They do not choose to die because this is a noble obligation. They die because of fear. And I think more casualties are being reported about North Korean troops in Russia, and that has led to growing dissatisfaction, particularly among the bereaved families. They feel that they are critical about the situation because their relatives have been sold off to this war fronts. And they do not receive sufficient information about what their relatives, their soldiers' whereabouts in the war front. They're also critical about this as well. As of today, North Korea has dispatched the large-scale construction brigades under the pretext of the post-war reconstruction. And they are providing the Russian language lessons to Russian soldiers that are to be dispatched to the north. As we also talk about the shifts in human rights awareness among the North Korean residents, that this is a comprehensive assessment. I believe that there is an intensified sense of fear, but there's also growing awareness about human rights, the concept. And I think people are developing better understanding about human rights. And this shared understanding about the values of the human rights is to bring changes in North Korea. This is leading to the defection to the outside world in a collective manner. I think such changes represents a potential foundation for democratization within North Korea, and that may serve as a driving force for future changes. I also note the expansion of critical perceptions towards state-led, the human rights policies. A growing number of residents recognize that Kim Jong-un's policies and prioritizing of North Korean development, military expansion constitute a structural violence and that is irrelevant to the livelihoods of their lives. Many people are developing this negative understanding, and particularly those who have been exposed to the outside world, such as the overseas workers, they are developing critical views about the North Korean authorities. And there are also the overseas workers who reside in Southeast Asia as well. And they also express a disappointment with regards to neglect of the South Korean government and also to this international community. North Korea has labeled Republic of Korea as a hostile state, but South Korea regards North Korea as a partner for peaceful engagement. This is an ironical situation, and North Korean residents are quite critical about the situation because those who are critical about the authoritarian nature of North Korean authorities tend to be very critical. Some people have been imprisoned, and I'm sure that they would have developed such a critical view about North Korean authorities. But the residents want freedom. I can assure you that. That is the current situation in North Korea. So let me draw some conclusions today. I think the critical element in addressing the human rights situation in North Korea is acquiring information. The international community should establish a North Korean human rights information hub that can systematically integrate defector network, satellite data, and testimonies from overseas North Korean workers. Non-military intervention mechanisms to protect North Korean residents must be concretely established. Political resolutions calling for accountability should be pursued at the United Nations and within the national legislations. There should be better information provided on human rights issues, and democratic support for North Korean residents should be provided. Information should be provided, and education content should be strengthened. Lastly, I like to say that the will of the people dream of freedom is stronger than a dictator possessing nuclear weapons. So our discourse should not focus on the nuclear weapons per se. It should be more about the will of the people, the dream of freedom. The spirit of the R2P we discussed today is not merely a normative principle. It represents the conscience of the international community directed towards our brothers and sisters in North Korea who continue to live under oppression at this very moment. Thank you very much for your kind attention.
Thank you very much for this excellent presentation and also for providing some insights into the life of people in the DPRK. Next, we have Mrs. Kim Jeong-Ah, also originally from the DPRK. She's a fierce human rights defender and the founder and representative of TongilMom, an organization focused on advocating for women's rights. She will be presenting their latest report, which is a survey conducted on healthcare policies, and she will provide information on how to improve women's rights in the DPRK. Thank you very much, Mrs. Kim.
네, 안녕하세요.
Good day, ladies and gentlemen. I am from TongilMom. I am Kim Jeong-Ah. TongilMom is RFNK, or Rights for Female Defectors from North Korea, and I will be presenting today on the topic of the survey of health policy conditions for improving human rights of North Korean women. TongilMom, or RFNK, is a victim-centered human rights organization in which victims and their family members directly participate to protect the human rights of North Korean women and children. And we're not simply an organization that speaks on behalf of human rights in North Korea. For the past 10 years, we have been a policy-driven organization connecting victims' own testimonies to actual policy outcomes so that their experiences lead to institutional change. Yesterday, during session 2 of the R2P conference, as I listened to cases of human rights violations in Myanmar, I wanted to ask the following questions. Why are women and children the first and the most deeply left without protection in Myanmar and North Korea? And when a state abandons its duty to protect its own people, to what extent can the international community act in solidarity and discuss responsibility? These questions align directly with the content I will be presenting today. Women and children in North Korea are equally rights holders who must be protected, and the fact that these rights are being structurally destroyed is at the core of the problem we are addressing. The testimonies and data we have collected are not merely records of suffering. They are human rights evidence demanding policy-level responses. Victims' voices must now go beyond simple testimony and be presented as the foundation for international policy and cooperation. This study analyzes North Korea's healthcare reality using the standards of UNCRPD to expose the falsehood of North Korea's proclaimed free medical care system, reveal the reality of a collapsed healthcare infrastructure, and demonstrate that the health rights of women and children, maternal and child health, must be the starting point for restoring human rights in North Korea. TongilMom in 2025 conducted a survey on healthcare-related human rights violations in North Korea, and this is based on in-depth testimonies of North Korean escapees. The study integrates multiple forms of evidence, including objective choice-based data, cross-analysis tables, descriptive narrative responses, and comparative analysis with international norms to examine the structural violations of healthcare experienced by North Koreans residents. The results show that North Korea's healthcare system remains only a formal institution and that there is a fundamental gap between the system on paper and the actual guarantee of rights. In particular, the study structured the issues around 7 key domains: healthcare infrastructure, medicine, maternal and child health, children with disabilities, women with disabilities, disabled war veterans, rural blind spots, and additionally it examined special cases involving children with disabilities, including human experimentation, intentional killing, and genital mutilation. This survey was conducted from May to June 2025 with 100 North Korean escapees living in South Korea, and among the most critical and crucial indicators in testimony-based research is the year of defection. Notably, 47% of participants defected during the 2010s, making this survey particularly valuable for capturing the healthcare conditions under the Kim Jong-un regime. Furthermore, 58% of participants personally had a disability or had a family member or acquaintance with a disability, making them highly suitable as respondents for assessing healthcare-related human rights conditions. According to the survey, North Korea's healthcare infrastructure is in a state of near total collapse. 72% of respondents had never received a routine medical checkup. 64% reported that access to hospitals was either impossible or extremely limited. In emergency situations, not a single respondent had used any public emergency transport, and instead, 67% walked or were physically carried by family members to reach a hospital, and 19% reported attempting self-treatment at home. Regarding pharmaceuticals or medicine, 81% purchased medicine from markets or private traders, showing that hospitals provide almost no medical supplies. Furthermore, 64% had used fake or substandard drugs, indicating that quality and safety of medicines are virtually unregulated. And lastly, those that have directly experienced or witnessed medical accidents amounted to 63%. These findings demonstrate that North Korea's medical environment is not merely a public health issue, but a structural crisis where life and human rights are simultaneously threatened. As of 2025, testimonies from mothers inside North Korea confirm that infants born with disabilities are immediately labeled by family and local communities as useless beings, and there were attempts to kill the baby right after birth. The photo shown here is of a child's foot with 8 toes, so a child with disability. And due to technical issues with the live stream, I will describe the situation in the testimony video that viewers could probably only rely on the footage rather than audio. So I do ask for your understanding.
안녕하세요. 저는 살고 있는 안녕하세요. 저는 살고 있는
So I'm a 24-year-old mother, and I got married in March 2022 and got pregnant a year later and gave birth in December 2023. Tragedy struck the moment I gave birth. The baby was born with disabilities, and the third and fourth fingers on the right hand were fused together. And the baby had 8 toes on the right foot. And my in-laws said it was a cripple and told me to kill it.
실제 증언자는
And the mother in the testimony was a very young mom, and as you can see, she was abandoned by her own family and by her in-laws. And in the interview, she's been sighing after every sentence, so there was a lot of editing that was required.
진정에서도 저와 아이를 내쫓았습니다. 출산 한 달 만에 쫓겨나서 갈 데도
북한 사회에서 장애 아동, 특히
So especially a parent raising a child with disability makes it very difficult. Because of the social stigma, it ends up with even the family members abandoning the child, as well as the mom.
받아주지도 않고 저와 아이는 모두 외면당하는 가족에게 모두에게 버림을 받았습니다. 결국
엄마와 아이는 결국 거주
So the mom and the mother and child experienced 4 layers of exclusion: the loss of residency, loss of family protection, loss of livelihood, and the loss of access to health care.
이는 아동의 생명과 존재 자체를 부정하는
This basically disregards the life to right of the child.
살고 있는데 이곳에선 집도 아니고 초막을 싣고 있어서 겨울이면 너무 춥고 여름엔 장마가 져서 무서워요.
저 처막이라는 것이 여러분이 한국
And the makeshift hut that she lived is not like a camping tent. It's basically like a hole bored in the ground. It's not at all a condition where somebody can live.
그러다 보니 출생신고도 못하는 상황이고 아이를 어떻게 키워야 할지 공부는 또 어떻게 시켜야 할지 고름도 제대로 고를 수 없는 이 아이는 앞길이 막 캄캄합니다. 솔직히 쓸모없는 인간
장애 아동 치료의 지원 부재는 단순히 의료 문제를
The absence of treatment and support for children with disabilities is not merely a medical issue. It exposes the structural reality of state irresponsibility and systematic social exclusion. So you can see that there is that very blind spot, and it leaves them uncounted and completely outside the scope of statistics or policy.
이번 조사 결과 북한의 모자 보건과
The results of the survey confirm that North Korea's maternal and child health system, as well as its health management for vulnerable populations, is in a state of severe collapse. Among respondents, 58% had never received a single prenatal checkup during pregnancy, and also reported receiving no medical assistance at all during childbirth. In contrast, 84% said that they had received vaccinations, indicating that only a formal prevention-focused system remains, while there is effectively no functional prenatal or postnatal care system. Within the domain of child health, 47% reported experiencing severe deterioration, and 21% had personally experienced the death of a newborn or child. This goes beyond inadequate medical infrastructure. It indicates the complete absence of state-level caregiving and emergency response systems. In the area of children with disabilities, 76% received no treatment support whatsoever, and 88% were denied disability registration or never had the opportunity to register. And this is not just one sole case that we've seen in the video. This demonstrates the children's right to survival and development is being institutionally denied. Regarding women with disabilities, 95% received no support for pregnancy or childbirth, and 61% experienced medical refusal or discrimination, and 100% reported never having received psychological counseling even once. This demonstrates that women with disabilities are completely excluded from both the right to life and the right to reproductive health. We will view this testimony in another video as it describes what happens to honored veterans in a country where medicine has effectively disappeared and their lives are left entirely to their families. This shocking case involves a mother who cultivated poppies to ease her son's unbearable pain after his leg was amputated. She used the opium as a painkiller and was detained by state security authorities and then later released.
같은 데 간다고 이제 키도 크고 좀 체력도 돼가지고 그런 데를 갔어요. 근데 몇 년 만에 5년 만인가 세대대 왔다는 거예요.
이 동창은 실제
And you can see that his son has worked for a special unit. And he was noted as someone that people did look up to.
그런 줄 알았는데 치지 않았던 다리까지 옮겨가지고 특파성 개조라는 병이라고 하더라고요.
So he was admired amongst his colleagues. But then again, we had the son come back with one toe amputated. However, as time passed by, his limbs had to be amputated one by one when he returned back home.
많이 마치고 했지만 이 병이 멈추질 않은 거예요. 계속 그러던 찰나에 누가 양귀비를 마지막으로 써봐라 이런 조언을 받게 되어 그때부터 주사를 놔보자 해서 놨는데 두 손가락이 썩어 들어가다가 멈춘 거예요. 그래서
이 사람은 단순한 개인의 비극.
And this is not one single tragic incident of a household. This indicates the institutional failure of healthcare in North Korea.
나라를 위해서 가서
국가를 희생했지만 병사들.
So you can see that in the case of their soldiers, they were just shields. They weren't persons. And they were not respected at all. And you can see that these videos all offer the consistency for the fact that there is functional collapse.
파란 것도 없고 심어서 내 아들을 살려보려고 마지막으로
정규 의료 체제가 사라진 자리는
In the void left by the vanished formal healthcare system, drugs such as opium and methamphetamine have taken its place, and even these must be cultivated, purchased, and administered by residents themselves. Testimonies from medical workers confirm that poppy-based substances are widely used as substitutes for antibiotics, intramuscular injections, and painkillers, and that even hospital staff repeatedly recommend or directly produce narcotics as alternative medicines for patients. The state's failure to treat disabled veterans and its private outsourcing of rehabilitation burdens result in women and families carrying long-term caregiving responsibilities, and this reflects a structural distortion in which healthcare resources are allocated to regime preservation and military priorities rather than basic civilian medical care, thereby infringing upon women's reproductive rights and economic independence. Thus, analysis of disabled veterans' cases was used in this women-centered human rights study as supporting evidence showing how selective health resource allocation causes indirect harm to women. In North Korea's healthcare system, the military concentration of medical resources has resulted in most health budgets being diverted to military spending, and consequently, civilian healthcare has collapsed and regional inequality has intensified, producing a stark contrast between privileged Pyongyang-based medical services and the near total absence of healthcare in provincial areas. The expansion of the informal market forces residents to buy medicine in markets instead of hospitals, causing widespread harm from counterfeit drugs. Political discrimination determines who receives treatment based on social class and perceived loyalty, and ultimately, North Korea's healthcare crisis is not merely a collapse of medicine, it is the structural consequence of governance without human rights. The three pillars of the proposed policy roadmap are as follows. First is institutionalizing maternal and child health. It's to establish minimum standards for prenatal, postnatal, and intensive newborn care and create an emergency transport system. These should be embedded into international human rights indicators to institutionalize the state's healthcare obligations. Second is building a disability and intersectional support system, creating continuous system for early detection, registration, referral, and rehabilitation for women with disabilities and children with disabilities, and building a comprehensive healthcare support framework that includes rehabilitation and psychological treatment. Third is strengthening equity-based assistance and international cooperation, establishing a differential support system to eliminate cost barriers and prioritize vulnerable groups, and promote transparent healthcare financing to reduce regional disparities in medical access. This roadmap positions the health rights of North Korean women and children as the starting point of human rights policy and transforms victims' testimonies into institutional action, leading to international cooperation and structural policy change. This study is not merely a report meant to expose the realities of North Korea. It is a blueprint for change designed to help North Korean women and children reclaim their right to life and their right to live. Through the testimonies and data collected by TongilMom over the past several years, we have confirmed clearly that human rights violations in North Korean society are not simply matters of politics or ideology. They are issues of structural collapse in the basic systems of life itself. TongilMom will continue to conduct policy research to prepare an integrated maternal and child health model for post-unification grounded in the lived experiences of insights of North Korean women. We hope that the proposals and discussions presented today will reach North Korean women and children and become the first spark of change that restore their lives. TongilMom will continue creating a genuine path of change where victims' testimonies become institutions and institutions become life. Thank you.
Thank you, Mrs. Hello. Thank you, Mrs. Kim, for this excellent presentation. Also to include this live audios, I think it provides us a very concrete and human face of the violations we've been talking about. We will now turn to our last panelist. Mrs. Juliana Bieg is a researcher with PSCORE, and she will present her research on bridging disability rights and the principle R2P for the DPRK. Juliana, please, thank you.
Yes, thank you for your introduction, and thank you to my fellow panelists for discussing such important issues. I really learned a lot. My name is Juliana Bieg. I'm working at PSCORE currently as an intern and project manager in the ongoing research project about the human rights implications of the North Korean IT worker program. During my presentation, I aim to bring together two strands, R2P and its protective logic with the emerging recognition within the UN system that persons with disabilities face heightened risks of becoming victims of genocide and other atrocities. Indeed, disability is gradually included within global protection norms. My focus today is how the situation of persons with disabilities in North Korea can be articulated in relation to this global norm of R2P, this political commitment, and what a disability-inclusive R2P lens might mean for the North Korean context. As someone with an anthropological background, I want to begin with a personal reflection. While preparing my presentation, I often felt a certain discomfort or even guilt when trying to categorize evidence, experiences, and elements in North Korean escapee testimonies strictly according to whether they meet the R2P threshold or not. I felt as if this established a hierarchy of suffering which felt at odds with my own sense of responsibility to protect those who are currently enduring and surviving a highly repressive regime in North Korea. R2P's operational principles of a narrow but deep approach implies that once R2P atrocity crimes are identified, it empowers the international community to act early and decisively. However, it also implies legal boundaries. R2P operates within existing international criminal law, particularly the Genocide Convention and the Rome Statutes. It does not redefine what counts as a crime, but rather clarifies political and institutional responsibilities when such crimes occur or are at risk. R2P can therefore not be invoked for broader human rights violations, humanitarian suffering, economic hardship, regime change, and democratic transformation. In the DPRK context, the central question is whether persons with disabilities are legally recognized as targets of systematic destruction or persecution constituting atrocity crimes. The scale and the systematic nature of violence must be determined under international law. There are several sources of international criminal law to assess the R2P crimes in relation to specific social groups, but the term protected groups is rather narrowly defined. For example, the Genocide Convention lists only national, ethnic, racial, and religious groups. Under current international law, disability alone does not constitute under international criminal law, disability alone does not constitute a protected group for genocide, although disability-targeted killings can amount to crimes against humanity. Under Article 7 of the Rome Statute, most crimes require no discriminatory intent. Only persecution requires proof that the targeting occurred because of disability or another identifiable ground. Whether these acts meet the threshold of extermination requires further evidence on scale and stage policy. Isolated cases do not meet the standards. To then assess whether we can consider the DPRK's treatment of persons with disabilities meets these criteria, I will briefly introduce the UN mechanism monitoring the situation of persons with disabilities and then analyze evidence through the lens of Article 7 of the Rome Statutes. The United Nations Committee on the Rights of Persons with Disabilities, CRPD, monitors the implementation of the convention by state parties. It focuses, among other things, on protection from discrimination and violence, access to education, healthcare and justice, and the participation of persons with disabilities in all aspects of life. In August 2025, it reviewed the DPRK's 2018 initial report. For this context, PSCORE contributed a shadow report drawing on interviews with recent DPRK escapees and those with disabilities. Although the CRPD, the CRPD convention is not international criminal law, its findings may be indicative of patterns consistent with crimes against humanity and provides a powerful lens to identify discriminatory and violent practices in general. For CRPD Article 10, Right to Life, the committee reported credible evidence of infanticide of children with disabilities, including killings carried out in medical facilities with official approval. It also noted discriminatory eugenic policies and the systematic denial of medical care. These violations may constitute murder, persecution, and potentially extermination under the Rome Statute, reflecting a deliberate and targeted threat to the lives of persons with disabilities. Second, CRPD Article 14, Liberty and Security. Persons with disabilities, especially those with intellectual and psychosocial impairments, face arbitrary arrest and detention, often without due process. These systematic deprivations of liberty suggest imprisonment and persecution. Third, CRPD Article 15, freedom from torture or cruel, inhumane, or degrading treatment. The committee documented solitary confinement, denial of health care, punishment for non-productivity, and medical or scientific experiments on persons with intellectual or psychosocial disabilities. These acts of systematic abuse and neglect are consistent with torture, persecution, and other inhumane acts. Fourth, CRPD Article 16, freedom from exploitation, violence, and abuse. Reports indicate that severe violence, physical punishment, and restraints are taking place if forced labor quotas are failed. These violations fall under persecution and other inhumane acts. Fifth, CRPD Article 17 on protecting the integrity of the person. Women with disabilities are reportedly subjected to forced abortions and sterilizations and coercive medical treatments, including the use of physical and chemical restraints. These abuses violate their physical and mental integrity and correspond to persecution, torture, and other inhumane acts. Sixth, CRPD Article 22 on respect for privacy. Persons with disabilities in detention are reportedly subjected to strip searches and inspections under the guise of hygiene without explanation or justification. these acts constitute other inhumane acts. All of this taken together, these observations document patterns of segregation, institutionalization, discrimination, deprivation of liberty, and medical abuse, which may amount to crimes against humanity. I now turn to the normative limitations within R2P. The operational principle of a narrow but deep approach restricts R2P to legally defined atrocity crimes. Definitional criteria for the narrow scope were derived from normative considerations preceding the historical R2P consensus in 2005, but this criteria also comes at a certain cost. The strategic minimalism makes R2P normatively thin. It creates political viability, but avoids deeper commitments to human dignity, substantive equality, or inclusive justice. The normative thinness constrains the protective and transformative potential of this global R2P norm, especially when it does not clearly define what protection means, and when structural or everyday violence fall outside its scope. R2P discourse also rarely envisions why individuals are worth protecting and empowering beyond a procedural right to be free from atrocity. Disability remains marginal within the R2P discourse, and explicit connections to disability remain underdeveloped. The R2P threshold defined by international criminal law prioritizes exceptional cases of violence, and there are valid reasons for such a normative lens through which a specific need for protection becomes articulated and inspires international actions. But this normative mechanism creates blind spots around structural violence, meaning the systematic, often invisible ways in which political, social, economic, and cultural structures harm people by limiting their life chances, dignity, or well-being. The structural violence operates also in non-war situations and is usually obscured due to a dualism between war and peace, where peace is delineated by its alleged absence of violence. Such blind spots are also distort the structural violence that manifests as colonial and post-colonial violence. Structural violence is not itself an international crime, but is relevant as a risk factor under the UN framework of analysis for atrocity crimes. By articulating atrocity crimes as the ultimate threshold for mass violence, R2P risks missing the structural violence that shapes people's daily lives, also in North Korea. And that is why the monitoring of early risk factors is such an important mechanism to prevent recurrence of violence, as well as to strengthen early warning mechanisms that inform strategies for prevention. After the UN Security Council acknowledged in Resolution 2475 the heightened vulnerability of persons with disabilities in conflict in 2019, the UN Office on Genocide Prevention and the Responsibility to Protect issued a guidance note on persons with disabilities in October 2024, which signals a more inclusive understanding of risk. However, disability-specific harm often remains depoliticized and medicalized, framed as issues of care rather than potential atrocity risk factors. At this point, I would like to briefly share those CRBD findings that do not meet the R2P atrocity threshold, but remain, in my eyes, essential to document atrocity crimes and understand how structural violence functions and connects with atrocity crimes, because this violence is so deeply entrenched in institutions, policies, societies, and everyday life, not only in North Korea. In North Korea, many persons with disabilities face institutionalization and isolation and are often confined to segregated settlements with limited access to schools, work, or social life. Children, especially in rural areas, often lack early diagnosis and inclusive education. Legal and social recognition is limited. The Constitution doesn't explicitly prohibit disability-based discrimination. For example, denial of accommodations is not recognized as discriminatory. Cultural ideals valuing physical strength and productivity further marginalize, particularly outside Pyongyang. This especially affects women and girls with disabilities. They face severe barriers to education, employment, social welfare, and political participation. Access to healthcare, rehabilitation, and basic services are highly unequal. Facilities are often inaccessible, rehabilitation centers are underfunded, and malnutrition disproportionately affects persons with disabilities. Adults are discouraged from marriage and excluded from adoption. Ultimately, the lack of visibility and participation reinforces structural violence. Awareness campaigns are scarce and reforms often fail to reach those affected. Overall, disability-specific harm in North Korea arises from institutionalization, neglect, discriminatory policies, reproductive violence, starvation, segregation, and erasure of legal personhood. While these issues may not meet the threshold of R2P atrocity crimes, they are forms of systematic, everyday harm that must be documented as they create conditions of deep vulnerability. Disability-related documents and initiatives that have responded to the normative thinness of R2P by introducing risk factors are important because they understand disability not as a characteristic, but rather as a socially produced risk. Disability-specific harm manifests frequently in administrative and medicalized ways, and the conception of disability as a characteristic depoliticizes harm. If absorbed into stereotypes of care, protection, and management, it risks the exclusion of disability-specific harm from atrocity imagination. This problematic dynamic also manifests in the discrepancy between the systematic targeting of persons with disabilities on the one hand and the DPRK's political cover and rhetorical protectionism on an international level, and the protective pretext embodied by the KFPD, the Korean Federation for the Protection of the Disabled in North Korea, on the other hand. Disability-inclusive frameworks should refrain from reinforcing and instead intervene in these dynamics. Calling out this discrepancy as a sort of state duplicity can also help counter European exceptionalism and critique more holistically a system that reinforces structural violence as well as marginalizing dynamics by imagining certain populations as only passive, vulnerable, and in need of protection. The normative thinness of the R2P framework then also impacts R2P analysis and research on atrocity prevention. Blind spots and omissions in analytical frameworks could engender epistemic violence, meaning a form of violence that we as researchers may perpetrate while doing research. And it's this concept of epistemic violence that helped me make sense of the discomfort that I mentioned at the beginning of my presentation. We risk reproducing harm by excluding, silencing, or distorting certain experiences, or by representing them in ways that distort lived realities. Dismissed knowledge, experiences, or perspectives, and a disability-inclusive R2P analysis must be aware of the risk and avoid reinforcing these patterns. To conclude on a more hopeful note, in this presentation I have argued that integrating disability into the R2P framework to expand the protection agenda requires normative critique as well as cautiousness around one's own positionality. But another strategy in the expansion of a protection agenda might also mean choosing engagement in addition to accountability. At PSCORE we document human rights violations and also identify windows of opportunities, meaning past moments where engagement with the DPRK government has been working to engender positive change, as they might point to avenues where engagement might work again. To name a few, constitutional, criminal, and procedural law amendments in 2024 removed derogatory terminology. The 2023 law on guaranteeing the rights of persons with disabilities recognizes cultural, economic, and educational rights. Following the law's adoption, the Korean Federation for Protection of the Disabled in North Korea experienced a substantial increase in its political activity. The Special Rapporteur on Rights of Persons with Disabilities was allowed to visit the DPRK in 2017. And more recently, it was reported that on April 1st this year, a kindergarten class for hearing-impaired children was launched as a pilot program of a new education support system, and there are plans to expand in 2026. These reforms remain uneven and often inaccessible outside elite urban contexts, but documenting these developments is essential to understand and build knowledge on how harmful structures operate across both peacetime and wartime, and where intervention is possible. Securing evidence about this progress not only gives hope in the context of ongoing mass atrocities that some suffering and harm can be reduced or even prevented, it's also a powerful tool to counter the DPRK state narrative and benevolent facade on disability rights. To come to the end of my presentation, when arguing for an expansion of the protection agenda, I don't mean softening the atrocity threshold for future R2P initiatives, but to recognize structural violence as part of atrocity risk and to recognize our epistemic responsibility when representing how power operates and violence manifests, ensuring that our own analytical frameworks do not reproduce the very silencing and distortion we aim to challenge. There are certain mechanisms where multiple representations converge, each bringing a distant viewpoint which collectively generates a richer understanding of a phenomenon. This includes the Universal Periodic Review, a UN process where every country's human rights record is reviewed by all other member states. It's a cooperative peer review mechanism that examines progress, identify gaps, and issues recommendations. And finally, with expansion, I also mean critically reflecting what we mean with protection, to enrich accountability and prevention initiatives, as well as transitional justice perspectives, the set of practices, mechanisms, and concerns, the judicial and non-judicial mechanisms that societies, including the Korean society, can adopt following a period of conflict and repression. Thank you.
Thank you, Juliana, very much for not only bridging disability rights and R2P, but also this panel on DPRK and the next one that will be talking more about crimes against humanity and on qualifying the facts that we've been talking. I see that we still have some time for questions. This was not included in the program, but I think we have here so many.
Sorry, we have an alternative program planned.
Okay, I'm sorry, so no questions, but I mean, we will all be here during lunchtime, so please approach this excellent panelists and please give another round of applause to all of them. Thank you very much.
Thank you to everyone for your valuable contributions and your continued efforts to shine a light on human rights violations in North Korea. You may take a seat with the audiences again. As we are ahead of our initial schedule, we would like to use this time for interviews with some of the North Korean defectors present here today. PSCORE's president and attorney Kim Tae-Hoon is going to interview them for us. So once everybody is settled back in the audience seats, we will continue with those interviews. Attorney Kim will take over for me now.
Good morning. I'd like to introduce one of the distinguished guests who just arrived. He was former chairperson of the National Civil Rights and I'd like to introduce one of the distinguished guests who just arrived. He was a former chairperson of the National Civil Rights and Public Grievance Commission, ministry level. And he also served as a presiding judge of the International North Korean Political Prison Camp. We opened last year, International Tribunal, Moot Tribunal, and he served as a presiding judge. Mr. Jung-Ah, please. Thank you. And lastly, I'd like to introduce also, it was not on the program, but she is a very important North Korean defector. And she's now running NGO for the North Korean human rights. So please, Choi Byung-Lim, you're on the floor. She will briefly testify.
안녕하세요. 저는 경기.
Good day. I'm currently living in Gyeonggi-do. I am Lee Byung-Min and a defector. I want to mention that I am a family of the victim of North Korean human rights violation, and I'm here today to testify.
잠깐만요. 전 하나둘의 엄마로서 그 사랑하는.
I am a mother of a son, and I am a mom that survived but left my son in a devastated situation. And if my son is alive, he's probably in his 30s. But I left him in hell, and if he was alive, he probably would have led a very happy life with a family. However, in 2010 of June, in the process of defection, at age 17, he was arrested by China and he was forcibly repatriated back to the north. And then I've heard some devastating news afterwards, which was that my son was actually a traitor to the government. And although he was a juvenile, he has been tortured and investigated throughout. And then all of a sudden he disappeared from the scene. He was detained in November, and still 15 years later, I still do not know the whereabouts of my son. And while he was in jail, he has said that my mom is not a traitor, and he has once again declared that he was going out to find his mom. So he really wanted to protect me, even in the face of torture. And just because he wanted to go and find his mom, he became a traitor, but he wanted to continue on to protect me. And I heard of that story, and that just broke my heart. He wanted to maintain my honor, but that was devastating. He, of course, did not have a dad because his dad passed away at very young. And he was a very caring son, and when I was sick, he was the one that decided to go out and get medicine. He went out to get water for me, and all of his clothes got wet, but then he was still smiling for me, and I still remember his smile and his face. He was someone that I could really say with conviction that there is no son like him. And as I face and as we were facing the borders of China, it was all lit up. However, North was completely different. And he asked questions, why are we eating these grains while other people seem to eat something different? Do we have to live this life? For him as well, as a young child, he found that this was very unfair. And I thought, we must find a way to break away from this hell. I did not want to hand this down. I really want to find a way to keep my son, have him relive his dream. So I decided to make the determination, and I made that decision, and I did not know that this would actually leave my son in hell. He's never left me, but my choice has led my son to jail, to be detained, and to death. We left for a better life, and is that a sin? If this is a crime, of course, we wouldn't feel this way. We wouldn't feel as devastated, but I wasn't able to protect my son. And for tens of years, I wanted to commit suicide. I wanted to take my life. But as time passed by, I found out that a mom that does not know the whereabouts of her son cannot die. I don't have a right to die. And that death valley, I still have the hope that I may be able to see and meet my son once again, and I'm still here alive. And implementing the Human Rights Act and alleviating the threat of forced repatriation and referral to the ICC and bringing the perpetrators to justice is the way for me to bring back my son to life. And please remember all of the sufferings and the pains. I am grievous of the fact, and I feel guilty of the fact that I wasn't able to save my son. And I wasn't able to save my son, but I am here out of my guilt toward my son, and as was mentioned by Mr. Jang, he's also, I know that he also has a family member, doesn't know whether his family member is alive at the political prison camps. And I want to mention that what we're trying to do of promoting human rights has to do with finding a way to save our family members. And we do have prisoners of war, of the Ukraine war, and there were two defectors and the moms to find a way to save their sons are really putting in their best efforts, but it's not something that we can ask of the South Korean government right now. It's about finding a way to mobilize international collaborative efforts, and we're putting in our best efforts to find a way to save these prisoners of war. But the government is not interested, and the DPRK is not interested in these prisoners of war, and therefore, for those that have the same pain, so the same the escapees that understand, have witnessed human rights violations of their family members are really putting in their best efforts to find a way to have the prisoners come back. And a female PD went to Ukraine in October and tried to interview these prisoners of war. And they went to Ukraine. What we were able to know was that they are alive, but I've heard that they were trying to commit suicide. They do not want to live. So how can we bring hope to these prisoners? How can we bring them back to Korea? So what we decided to do was actually bring video footages to these prisoners of war in Ukraine detained, and we really wanted to find a way to deliver our message of hope and also tell them that there are so many defectors and escapees living in the South. And so what we also decided to do was actually send handwritten letters to the prisoners of war. There were more than 30 or so handwritten papers or letters that were sent to the POWs. And we also contributed to a funding where there are also escapees living in Ukraine. And we wanted a way to actually provide foodstuff and provide funding to these escapees. And of course, they did not trust those that went to meet the POW, but when they saw the food, the Korean traditional food, they found out and they were first able to admit the fact that we were all brothers and sisters. When National Assembly member Woo went to the Ukraine, one individual wanted to come to South. However, after both of them read the handwritten letters and actually tried the Korean food, both they wanted to come back to, they all wanted to defect to South Korea. However, the fact that they were living in detained facilities in Seoul confinement, but they're so young, but there's no TV, there's no cell phone, and they're just there every day, just leading that every single day, day by day. But you can see that it was so painstaking, and they thought they just wanted to commit suicide if they had any weapons or arsenal, but they couldn't die, and they were just there. Just finding a way, holding on to the walls of their Seoul confinement. And the PD, the producer, has emphasized that both of them wanted to come to the South. So we wanted to let this be known to the international community, and the government can help us. We really wanted to put in our best efforts to find them to the South. So that was the message that we have today, and we're actually getting signatures to support these POWs to come to the South. So I really hope that we can bring together all of our efforts and to have these two POWs to come to the South. So I would like to seek for your support and assistance in this process. Thank you very much.
Thank you very much for that statement and sharing your personal experience with us. We will have our lunch break now. So just as yesterday, if you have green lunch coupons, please stay seated. The lunch will be served directly to your tables. If you have red lunch coupons, please move to the reception desk and meet the members of our PSCORE team that will escort you to a different location. We will resume with session 6 at 1:30 p.m. Please enjoy your lunch.
잠시 뒤에 오후 세션을 시작하겠습니다. 그래서 장내에 계신 분들은 자리에 착석.
Ladies and gentlemen, we are soon to begin this afternoon session.
Please be seated. We are starting at 10 past 1. 1시 10분에 시작하겠습니다. 그리고 발표자분들은 테이블로 이동해 주시면 고맙겠습니다. Also the speakers, please be seated on the table. Thank you.
Again, all speakers from session 6, please make your way up to the stage. While we are still waiting, this is a reminder to everyone to turn your interpretation devices back on if you need them, and check if they are working correctly.
This is channel 2. Channel 2 is reserved for interpretation into English.
We hope everyone had a good meal. Now, let us continue with session 6, which discusses applying R2P to crimes against humanity in North Korea. It will be moderated by Judge Park Sun-ki, Judge of UN IRMCT and former Judge of UN ICTR. Let us begin.
예, 안녕하십니까.
Good afternoon, ladies and gentlemen. Session 6 will be on applying R2P to crimes against humanity in North Korea. So that will be the topic for session 6, and we have 4 distinguished speakers to offer their insights to us. And as introduced, I am Park Sun-gi, and I am also from one of the co-organizers, Lawyers for Human Rights and Unification of Korea, or Hanbyeon, and I'm currently a vice president of Hanbyeon. And currently, I am judge at UN International Criminal Court. So then, let me first give the floor to our first speaker for session 6, Professor Cho Jong-Hyun. If I may briefly introduce Professor Cho.
Professor Jong-Hyun, Professor of International Law at Hankuk University of Foreign Studies. Professor Cho serves on several national committees dealing with inter-Korean legal policy, unification law development, refugee issues, and North Korean human rights. He has also previously worked with the Presidential Committee for Unification Preparation, the Korea Institute for National Unification, and the Korea National Diplomatic Academy. With his strong expertise in international law and human rights, he is well placed to speak on today's R2P related topic. Please welcome Professor Jong-Hyun.
예, 전 한국말로 발표를.
Thank you. I'd like to present in Korean. So the topic of my presentation is something that has been covered for the 2 days. So in line with the 20th anniversary of R2P, we've covered a lot of ground. And in the morning session, we heard testimonies and research results on North Korean human rights violation. Of course, we've seen the conclusion in the COI report. But in addition to that, in the face of these violations, I would like to also talk about how crimes against humanity, in addition to R2P, can be applied. And if I may go one step further, I also want to talk about the possibility of applying the genocide principles to the violations taking place in the north. So as a foreigner, we may wonder whether we do have the right to talk about the human rights situations in the north. But recently, Scotland has made it to the next round in the World Cup. And you may think whether Scotland is a state, but if you think about the state, you may note Scotland as a part of United Kingdom. But at any rate, international law has to do with the relationship among states. Therefore, human rights of a particular state may be thought as domestic affairs. However, as you are very well aware, traditionally, human rights, which was handled in the domestic level, has received different limelight ever since the Holocaust against the Jews. We have now the UN system that has introduced international human law, international criminal law, and ever since there has been various discussions, including the R2P discussions. So you can see that this is no longer a domestic affair. It's now an international challenge as well as an affair. And with regard to genocide, there is a what we call a genocide convention, another international norm. And then we have, ever since the Second World War, Human Rights Act as well as the Criminal Act. But if you think about the Genocide Convention, it's quite interesting. It has to do with human rights and criminal law. So it's more so like a hybrid convention. So the Human Rights Act, the Criminal Act, the Genocide Convention, and R2P, I can say that they're all intertwined. It's quite interrelated. So then, with regard to North Korea, what kind of obligation does North Korea have on human rights? What's directly relevant to North Korea? If you refer to what's in green, so I want to take this with a religious genocide note. So freedom of religion was indicated in green intentionally. So if you look at this slide, there's the Universal Declaration of Human Rights that was adopted as a resolution, and it's an international customary law. And Article 18 indicates the freedom of religion. And there's also as you know, if there's a treaty, typically you would ratify and you would become a state party, meaning that it will be binding. And if you look at the treaties where North Korea is a party state, there are actually a total of 5. We have ICCPR, and this also indicates the freedom of religion. And then there's the ICESCR, and then we have CEDAW, and we have CRC. And this CRC also indicates the freedom of religion. And there's also the CRPD. So all of these human rights treaties are have been ratified by North Korea. And in addition to that, I've mentioned that there is a treaty or a convention that has a human rights element to it, as well as the criminal code element, and that's the Genocide Convention. And North Korea is a state party to the Genocide Convention. And if you look at North Korea's socialist constitution, it indicates the freedom of religion, although it's a domestic act. So I just want to mention this for your reference. So I will not repeat what kind of actions were taken under the UN system. So there were the Human Rights Council, General Assembly, there were resolutions adopted on an annual basis. But at any rate, when it comes to genocide and the crime against humanity, when we want to apply that, we need to refer to the COI report, which also was repeatedly emphasized. So if I may just mention this just briefly, in 2013, COI on human rights of North Korea established by UNHRC as a special procedure, and there were relevant reports that were released, and the key mandate in the report was on crimes against humanity. So it was about investigating whether crimes against humanity did take place in the north. So if you look at some of the violations that were identified, there was, of course, political prison camps. So with regard to political prison camps, that's also crime against humanity. So you can see that there are a total of 9 patterns of violations on human rights. And freedom of expression also includes freedom of religion, as you can see in green. So after a year, in 2014, the conclusion was that all of the 9 violations were confirmed, and the most important mandate, which was on understanding whether there were any crimes against humanity taking place. So yes, it did. It was confirmed. And some of the evidence had to do with the persecution that took place in the political prison camps, and also in the prison labor camps, the oppression, the atrocious acts, and also for religious believers, persecution against particular religions, and persecution against those that have been forcibly repatriated. So these were all grounds that indicated that crimes against humanity did take place in DPRK. And then if you look at enforced disappearances and knowingly causing prolonged starvation was all confirmed, and referral to the ICC was recommended. And you can see that international criminal law and the international human rights law were mixed together. And it's not indicated here, but regarding genocide, there was a conclusion on that very fact, where after reviewing the possibility of a political genocide, genocide in the COA report said that it was a political genocide would be irrelevant. But my question here was that religious genocide may be possible, but why a political genocide? Why wasn't that reviewed? So that was the question that I had. So along with crimes against humanity, I really wanted to look into this genocide element. And we've been talking about R2P quite extensively. And in 2014, COI's basic conclusion was that in the case of Pillar 1, it indicates that it has manifestly failed. And now it's talking about the third pillar, that it's now this point in time where we've been switching on to now the third pillar. So, of course, that doesn't mean that the first pillar and the second pillar is long gone. but rather you can see that now the international community would have to engage in a stronger response and stronger intervention. So the COI report has confirmed the necessity of Pillar 3 to kick in. And in addition to the COI report at the National Assembly and UNSC, and in addition to that, recently the Trump administration has been also, talking about these elements. It was severed, but then again, it's now being raised again. And we also have the Seoul office of OHCHR, and it's not included in the COI report. However, a new issue that has emerged had to do with the overseas workers of North Korea. And regarding human rights violations, there were, many efforts made. So other than the UN, regarding targeted sanctions, UNSC hasn't taken any concrete action, but in the US, a North Korean Sanctions Act was established, which has led to executive orders and travel ban, asset freeze. So such actions were taken by the US. And something similar also was witnessed in the UK as well as in the EU. So you can see that anything that has to do with the MSS, it's all included. And then Kim Jong-un and Kim Yo-jong is now on the watch list when it comes to human rights. And domestic laws, other than what we've seen, we have in Japan, US, and Korea, the North Korean Human Rights Act has been established. In the US, it wasn't particularly just for North Korea, but as you can see here, it's in green. There is the International Religion Freedom Act of the U.S., and on an annual basis, the Department of State releases an annual report, and North Korea is noted as a country of particular concern. And there's also the U.S. Trafficking Victims Protection Act. And recently, due to the Shinhan, the salt fields that may lead us to actually be on the watch list. But at any rate, North Korea is indicated in the annual reports as a Tier 3 country. And what is the way to ensure individual accountability? As you are all very well aware, we do have the International Criminal Court and the Rome Statute of the ICC. Well, North Korea is not a state party, and as you know, without the UNSC stepping in, jurisdiction cannot hold, so there are some limitations to the Rome Statute. However, if you see here in the middle, there are 4 crimes within the jurisdiction of ICC and 1 regarding crimes against humanity. There are, conclusions made, and there is religious persecution included, but then if you look at genocide, religious genocide, was not covered in the COI report, and I believe that once we confirm the details, because ICC does have jurisdiction, it's something that can be referred to the ICC. And then we do have the hybrid court, or the mixed tribunal, and there are also other ad hoc tribunal options that have been mentioned, and applying universal jurisdiction, but it's not likely as of now. So this is not a first, but I do know that it can be a bit unfamiliar when it comes to what's on this slide. So I've mentioned that we do have the human rights law as well as the criminal law, but there are also different conventions. For instance, the 1948 Genocide Convention, that can be one way to resolve the problem. And I know that you may have heard of the discourse in other settings, but at any rate, we do have North Korea in green, and in 1989, it acceded to the Genocide Convention. And there are currently 153 state parties to the Genocide Convention. And the definition of genocide is indicated here in the middle of the slide. And as you can see in green, religious groups are of course included. So if we apply this to the North Korean situation, it does not have freedom to religion. So as mentioned, we do see cases of public execution, and maybe the 3 generations may be sent to the political prison camp. And Christianity is noted as a social sin. And you can see that there are probably devastating situations, and we have been seeing documents and testimonies and data on that. So, COI, about saying that religious genocide is not included, only political genocide is included. Well, I'm not exactly sure why that was the case, but the reason why I want to mention that this is a valid point that I'm raising here is because if you look at Article 9 of the Genocide Convention, ICJ, at the request of any of the parties to the dispute, will gain jurisdiction. So it's different from the domestic court when it comes to compulsory jurisdiction. So if there is any request prior or after, but if you look at Article 9 of the Genocide Convention, this convention does indicate that ICJ does have compulsory jurisdiction. So what this implies is that if one country or one party does want this to be referred to the ICJ, it can at the request of any of the parties, not both parties. It doesn't have to seek consent. So if you think about human rights obligations, and human rights is an obligations erga omnes. So in other words, even if it's a case where your citizen has not been harmed, if a human rights violation takes place in another country, but now I've mentioned it's not a domestic affair, it has been internationalized, so it may not have direct relevance with what's happening on my territory. However, we do have common responsibility to lift any violations. So that's why, according to the Genocide Convention, once again, it may seem irrelevant to our state affairs. However, if you are a state party to the Genocide Convention, if you see and identify any violations that take place on other territory, you can refer this to the ICJ. And there was one case, Gambia of Africa versus Rohingya of Myanmar, and Gambia has referred this to the ICJ. And then we have South Africa versus Israel on Hamas, where it has been referred to the ICJ, and a provisional measures have been ordered. The merits is still in preparation. It's still underway. No conclusions have been drawn. And I believe that, last but not least, if we talk about North Korea is a state party to the Genocide Convention. And once again, there are 153 state parties. And for all of the 150 or so state parties, if there are any issues that they identify, you can actually refer this to the ICJ. So there's compulsory jurisdiction at a request of any party. So you can see that compared to any other human rights treaty, it has a stronger role that it can play, and I've seen this come to work. So genocide, it's very difficult to actually satisfy all of the intents, the conditions. It's very difficult to establish the items that are required. So that's why extermination has been included. Crimes against humanity is murder and extermination, and that's probably the softer way of putting genocide. But at any rate, you have to refer this to the ICJ under crimes against humanity. But if it's genocide, it can be referred to ICJ. So what party is not a state party? There's UK, Korea, and there's also the US. But of course, this shouldn't be reserved. But in the case of the US, they've held the compulsory jurisdiction on a reservation. So based on the principle of reciprocity, it cannot be done. But in the case of the UK, they did not put this on reservation. They have accepted all this, and all of these clauses have been accepted. So I've talked about Gambia and South Africa. So whichever country it may be, as long as the country has not sought out for an exemption or a reservation, any country against the regional religious genocide threat in North can actually have this referred to the ICJ. So I think that it's important to understand that there are such avenues that do exist. And if we can maybe fill the gaps when it comes to data and information, maybe this could be one important spark of another movement, another campaign forward. So bringing this all together, I know that we're seeing some stalemate on the North Korean human rights issues, but I think that we need to find a way to seek progress. And there are many insights in this comments that were made, I think that are all meaningful. So we need a multi-tiered approach. And
국제사회의 상수로서 해결돼야.
If it does remain as an outstanding challenge, I think that we do need to understand what can be done, understanding and identifying new channels and avenues. So I want to mention that genocide, along with crimes against humanity, could be another avenue that we can take, and it has certain grounds. And as mentioned, if we consider the jurisdiction towards ICJ, along with crimes against humanity, of ICC, I think that genocide convention or the genocide threat in line with ICJ can also be an avenue, and it has a relevance with R2P, but this could be a third pillar approach, but still the first and second pillars would have to be addressed. But also in terms of pillar 3, I think that there could be more brainstorming that we can do together. So recently, the UNSC and its role is critical. So I think we need to further work on how we can reform the INSC. But recently, when it comes to the Palestinian issue, Russia has abstained rather than opposing. And recently, a UNSC resolution just a couple of days ago has been adopted. That was quite some time since any resolution was adopted. So also with regard to ICJ, it has also released its advisory opinion on the climate crisis and the climate obligations. So I believe that we do need to review the roles of the diverse actors, and it's high time where we do need to join hands. So I wanted to share with you these thoughts. Thank you.
Thank you very much. Professor Cho has just walked us through the matters related to the R2P, especially with regards to COI. The 9 different types of pattern has been thoroughly explained by Professor. And he has also shown us some legal limitations that we face in the practical matters. In particular, he talked about Article 9 of the Genocide Convention to refer to the religious persecutions, which is quite prevalent in North Korea. If we can prove that, then we would be able to refer this to the ICJ, to the international community. This is a new area that Professor Cho has explored through his presentation. Regarding Gambia's the presentation of the Myanmar matter to the ICJ, he's Mr. Temba, and at the ICT, he is the administrator, the court administrator. And please go to the YouTube, search up his name, Mr. Tambatut, and you will see that he has given a very good explanations about the current situation. At in Africa, at the Rwanda Genocide Court in Jana Mirimana, I was involved in a case related to the public prosecutor general's case, and he was also participating at the trial as well. So he was the chief, the prosecutor general, and it was a prosecutor general's case, and he has also said that he would like to be invited to the Korean conferences so that he'll be able to present before the Korean audience to explain his experience and having dealt with this matter. When it comes to North Korean human rights situations, with regards to the religious persecutions of the Christians in North Korea, we need to acquire more data about how the persecutions took place, and perhaps with more documented records, we will be able to bring this to the ICJ for the accountability of the prosecutors. And I very much agree with him on that matter. And now I'd like to invite Professor Nam Seung-Hyun to give us a presentation.
Is serving the head of the Center for International Law at the Korean National Diplomatic Academy. Professor Nam has extensive experience in peace and security issues, including her work at the Ministry of Foreign Affairs and her academic roles at Korea University and Hankuk University of Foreign Studies. Today, she will speak on developments at the UN and accountability of the DPRK. Please welcome Professor Nam.
Because this is an international conference, so I prepared my presentation in English. And also, thank you for inviting me to this very meaningful conference. It's an honor to be here. I deal with many issues on international law, but I also have a strong interest in North Korea human rights issues, so that's why I've done some research in the past on North Korea issues. So I would like to share some of the research and information that I've obtained the past year or so through my research. So today I would like to talk about the developments at the UN. So Professor Cho already mentioned about some of the developments that have been happening. He also discussed about pursuing accountability against North Korea. So I would like to add on to his presentation to explain more about the work of the UN Security Council because we saw lots of developments at the UN Security Council. And I would also like to add about pursuing accountability against North Korea for its involvement in the Ukraine war, which I think has some implications as well. So first I will discuss about the UN Security Council discussions. So with regard to the North Korea human rights issue, we usually talk about the UN Human Rights Council or the UN General Assembly, but we should also note that there have been lots of discussions at the UN Security Council as well. But the UN Security Council members were not always able to agree entirely on whether North Korea human rights issues should be on the UN Security Council agenda because countries such as China and Russia opposed it for procedural reasons because they argued that North Korea human rights issues should be discussed at the UN Human Rights Council and not the UN Security Council because the UN Security Council is primarily responsible for dealing with issues that concern threats to international peace and security. Nonetheless, countries such as the US and other Western countries have taken a firm stance that North Korea human rights issues are issues that concern international peace and security because human rights issues are directly linked to the nuclear issue in North Korea. And a primary example is forced labor of North Koreans who are found to fund North Korean regime and their weapons programs. But more fundamentally, the reason the UN Security Council was able to put North Korea human rights issues on the UN Security Council agenda was because the UN Commission of Inquiry on the North Korean issue, through the 2014 report, declared that the DPRK, North Korea, was committing crimes against humanity, characterized by systematic, widespread, and grave human rights abuses carried out by the regime, institutions, and authorities. In other words, because crimes against humanity is occurring in North Korea, the human rights situation in North Korea becomes a threat to international peace and security, which provides grounds for the UN Security Council to deal with the agenda. So, crimes against humanity is clearly a threat to international peace and security because they are the most grave crimes of international concern. So soon after the COI report, the UN Security Council held its first ever closed-door area formula meeting on human rights in North Korea in April 2014. discussing avenues to hold North Korea accountable, including referring the situation to the International Criminal Court. So as you know, the UN Security Council has the authority under UN Chapter 7 to refer human rights situations to the ICC. And there have been cases in the past where UN Security Council referred human rights situations to the Security Council, such as the case of Darfur, Sudan, and so on. So it's always a possibility, but as Professor Choi mentioned, because there's likely to be opposition from certain countries, certain permanent countries such as China and Russia, that is unlikely at this point. But nonetheless, as you can see, there have been discussions at the UN Security Council, which is very significant, and the fact that it was put in the agenda of the UN Security Council shows that this is clearly a very serious international issue that needs to be addressed by the international community. And then, so after 2014, it continued to have the UN North Korea human rights issue on the Security Council agenda. And in December 2014, the Security Council, with support from 11 countries, including the US, United Kingdom, and France, was able to continue the discussions at the Security Council. But China and Russia continue to oppose for procedural reasons, as I mentioned before. And then in 2015 and 2016 and 2017, the Security Council continued to have North Korea human rights issues as part of its agenda, with support from US, EU, Japan, and the RK at that time. But no resolutions or Security Council statements were adopted. And then in 2018, there were preparations made to discuss North Korean human rights issues once again, but these attempts faltered due to lack of a vote to reach a quorum, with only 8 countries supporting the meeting. And this was around when the first Trump administration stepped in. And President Trump at that time was trying to have talks with the leader of North Korea at that time. So the discussions foundered at the UN Security Council. But then with the wake of the breakdown of the US DPRK summit in 2020, there was again call for the need to discuss the impact of North Korea's human rights issues regarding international peace and security at the UN Security Council again. Mostly US, UK, France, and Germany called for a reconvening of the UN Security Council meeting. But at that time, only closed-door meetings were held because, again, China and Russia opposed an open meeting at that time. And this pattern continued in 2021, but it was in December 2022 when it became back on the UN Security Council agenda on December 9, 2022, when the US and Albania proposed a closed-door meeting to discuss human rights issues in North Korea. And then after that meeting, a joint statement was issued by more than 30 countries at the time, which emphasized the severity of the North Korean regime's human rights violations and stressed that North Korea's human rights issues are inseparable from North Korean nuclear issue at that time. And other discussions took place in 2023, and then another meeting took place in 2024. And the one in 2023 was the first open discussion since 2017. So as you can see, there have been some discussions at the UN Security Council level through open and closed-door meetings. However, there still seems to be lack of consensus on whether North Korean human rights issues should be placed on the UN Security Council agenda, because China and Russia still continue to maintain the stance that UN Security Council is not the appropriate platform for discussing North Korean human rights issues. Nonetheless, they were able to push through the discussions. But also there seems to be different interpretations of whether North Korea's human rights situation constitute crimes against humanity. Despite the UNCOI's 2014 report claiming that there are crimes against humanity in North Korea, China and Russia have refused to acknowledge that there have been international crimes. So this difference in interpretation limits any kind of action at the UN Security Council level and for any concrete measures to hold the regime accountable. So the UN Security Council under Chapter 7, UN Charter Chapter 7 has the power to impose sanctions or refer the situation to the ICC, but because of this different interpretations and understanding of the situation in North Korea, they're not able to put forward legally binding resolutions against North Korea for human rights issues. Nonetheless, again, as I mentioned, the fact that it was discussed at the UN Security Council shows that this is a very significant issue that concerns the international community as a whole. And so as Professor Cho also mentioned, there have been many resolutions proposed by the UN General Assembly. And this year in May 2025, there was a high-level plenary meeting on the human rights situation in North Korea, which was convened by the president of the 79th session of the UN General Assembly, which was the first high-level meeting of the UN General Assembly on human rights situation in North Korea, which was also a significant event. The UN Human Rights Council, as you all probably know, have been providing lots of resolutions as well. And the UN Security General also submits reports on North Korea human rights issues to the UN General Assembly. And through these reports, as many probably you know, it's worth noting that the UN seems to take this two-track approach, which was mentioned by Elizabeth Salmon at the time, the Special Rapporteur on North Korea human rights. She said that we need to take this two-track approach in addressing the human rights situation in North Korea through accountability and engagement. So this seems to be the stance of the United Nations currently. And so with regard to accountability measures, Professor Cho already mentioned issues of accountability, but just to add on, so as Professor Cho mentioned, North Korea is not a party to the ICC and limitations still exist under the Security Council, as I mentioned. And even if the ICC were able to exercise jurisdiction over North Korea, even if ICC issues arrest warrants, it would be very difficult for the ICC to actually arrest, as it was seen in the case of President Putin and of Russia and Prime Minister Netanyahu. As you know, the ICC has issued arrest warrants against these leaders, but these leaders have not been arrested. Nonetheless, we may be able to look into domestic platforms and avenues, as it was proposed by the United Nations High Commissioner for Human Rights, which stated that the Republic of Korea has a comprehensive legal framework that allows ROK courts to exercise jurisdiction over human rights violations committed in and by the North Korea. So I think these options could also be explored. But I think it's also important to mention North Korea's involvement in the Ukraine war. Although it's not North Korea, as many of you know, North Korea was involved in the Ukraine war. It still is. And this first issue arose first when DPRK was supplying weapons to Russia. And this was confirmed later by Ukraine and Korean National Intelligence Service. And Russia and North Korea signed the Treaty on Comprehensive Strategic Partnership for their mutual defense obligations. So this was the basis for their cooperation. And North Korea's involvement was later confirmed when 2 North Korean soldiers were captured by Ukraine authorities on January 12, 2025. But even then, Russia and North Korea did not acknowledge that North Korea and Russia were involved in the Ukraine war. And North Korea has several legal justifications for its involvement in the Ukraine war. And they say it's legitimate for them to become part of the war in Ukraine because Article 4 of the treaty, which they signed with Russia, mandates mutual military support in emergencies, and that it is also in line with the UN Charter and international law. As you know, Russia has argued that it has no choice but to attack Ukraine as an act of self-defense, and they had responsibility to protect the Russian people in Ukraine. But on the other hand, the UN General Assembly has made it clear that Russia's active aggression against Ukraine is a violation of the UN Charter. And UN General Assembly Resolution 3314 has also found that North Korea's involvement in Russia constitutes an act of aiding an illegal act of aggression and also violates UN Security Council resolutions which ban cooperation with North Korea. So North Korea could potentially be held accountable for its involvement in Ukraine war. And it's worth noting that in Europe, the European Union recently announced to establish a special tribunal for the crime of aggression against Ukraine. Because the ICC cannot hold Russia leaders accountable for aggression, the European Union decided to establish a special tribunal. And there may be room for accountability against North Korea through this special tribunal, although it hasn't been confirmed yet, because it states in their homepage that there may have a jurisdiction to hold leaders of Belarus and North Korea accountable. So I think it's worth looking into these developments in the future as well. So I'll finish my presentation here. Thank you.
예, 남 교수님 오늘 발표.
Thank you, Professor Nam. Professor Nam walked us through the progress that we have made with regards to North Korea human rights issue at the United Nations, and also the North Korea's aggression into the Ukraine-Russian war. She was very systematic in explaining us about this, and since the issuance of the Se-Yul report, the North Korean human rights issue has been submitted to the UN Security Council and also referred to the ICC has been considered. And with regards to the special tribunal for the crimes of aggression, which is announced to be established by the European Union, I think it's very meaningful that you mentioned the developments made in Europe as well. The international humanitarian law and the UN charters, I think the fact that North Korea has not abided by these international norms, I think it gives us a good opportunity to reflect on what is to be done for the future for the South Korea.
Let me introduce Professor Boris Kondoha from Far East University. Professor Kondoha is a prominent scholar in international law and peace studies, and currently serves as the editor-in-chief of the Journal of International Peacekeeping. His professional background includes research at Goethe University in Germany and the teaching appointments at several universities in Korea. Today, he will present on the human rights situation in North Korea, an obstacle to reunification, addressing one of the core questions in the broad discussion on peace and the unification on the Korean Peninsula. Please welcome Professor Kwon.
I will have more questions than answers. Like yesterday, I also had to rewrite my own speech during the conference because other conference participants already covered certain aspects. My general question is, are the human rights violations in North Korea an obstacle to unification? Let's hope one day there is Tongil, the unification of North and South Korea. What will happen next? I think one approach will be the Koreans will try to come to terms with the past. I am living in Daejeon and I'm often cycling to a place called Tanbang. And there is a statue of a Wianbo, a comfort woman. And next to her, there is a statue of a former forced laborer. What I see is that the Koreans have a very good sense how to remember the past, and I hope that one day the people living in unified Korea will also have similar memorial places for remembering the atrocities committed inside North Korea. As I said before, coming to terms with the past is a very complex process. One way to deal with it is to establish trials. There's the hope that the trials will establish justice and the full truth, because I don't think we have a full idea what's exactly happening in North Korea. Let me now focus on the discussion related to transitional justice. Of course, the debate in Korea has not really started. Therefore, I would like to focus on the experience of my own country, Germany. Few questions for our discussion. One day, there is the day Korea is unified. And then someone comes up with the idea there should be trials. One of the questions is, what law should be applied? International law, South Korean law, or North Korean law? In case of the trials in East Germany, East German law was applied. Should there be an international tribunal? A mixed tribunal like in Cambodia or in Sierra Leone? Should there be a Korean court composed of South Korean and North Korean judges? Is there in general a duty to prosecute all crimes committed by the North Korean regime? How far will we go back in time? Should war crimes, like in Nogori, committed during the Korean War, be prosecuted? Is China not complicit in North Korea's serious human rights violations? Who should be put on trial? Only the leaders, the inner circle, the prison guards? Many questions. Will there be a role for a truth commission, like in South Africa? Are amnesties permissible under international law? Let me talk now a little bit about the experience of my own country. My conclusion is, do not expect too much. Avoid double standards. Do not give the North Korean people that they will get discriminated. And then I think a potential question which could come up is, what is the role of the South Korean leaders in keeping, what was the role of South Korean leaders in keeping the North Korean leaders in power? Of course, that's more a political question, but I think it will also automatically come up. Germany. Here on the slide you see the face of a famous social democrat from Germany. And he said once, unification is not a single action, but a process with many steps and stops. So there's also no clear answer how unification will take place. Probably the victims of violations in North Korea, they will complain about the cases brought before the court, that not enough people will be punished for crimes against humanity, for crimes perpetrated in the so-called Kwangli-so. How has my own country dealt with the crimes of the Nazi government and the crimes committed by East Germany? Probably you will all have heard how Germany has dealt with the crimes against the Nazis. There has been a big trial in Nuremberg, established by the Allied powers, the so-called Nuremberg trial. The leaders of Nazi Germany were put on trial, and the trial itself raised complicated legal questions. As I see it, the trial violated basic principles in international law, the principle tu quoque. So only the Germans were put on trial, but at the same time, war crimes had been committed by the fire bombings of German cities like Hamburg and Dresden. And then another principle had been violated, the principle of nullum crimen sine lege. There cannot be a crime without law. So at that time, two new crimes were invented. Crimes against humanity and crimes against peace. There was no clear rule in international law saying that the leaders who started an aggressive war should be held accountable. Nevertheless, don't get me wrong, these are just probably the technical academic issues regarding the Nuremberg trial, but I think important that we follow legal principles in the future. And then after 1945, trials continued in Germany. There were trials during the 1950s, but the German government in East and West Germany lost a little bit interest in prosecuting Nazis. And my conclusion is more people should have been put on trial. Then during the 1960s, there was the big Auschwitz trial in my hometown, Frankfurt, a very famous trial initiated by the prosecutor Fritz Bauer, a famous person. And I think this is also what Korea needs in the future, that there is leadership, not only political, but you also have legal leaders trying to bring the people who permitted crimes in North Korea would be put on trial. And then for many, many years there have been trials of former prison guards, people running prison camps, and then in Israel you had the Eichmann trial and so on. And then Germany got unified. One quick lesson I can tell you, be ready for unification. When I went to high school, my last high school trip was to East Germany, when East Germany was a communist state. No one could have imagined that 6 months later, people in Leipzig and elsewhere would go to the street and protest and say, we are the people. People asked for basic freedoms. And then Germany got unified. Again, the question of transitional justice came up. What happened? many of the East German leaders were too old. Honecker was not fit for trial, the last head of government in East Germany. And then the focus moved to the so-called border guards trials. What should you know about the border guards trials? Leaving East Germany without permission was a crime in East Germany, and soldiers at the border had to act under the order to shoot people. And these soldiers had been put on trial, and they were also sentenced to prison sentences because of manslaughter. Very complicated cases. The border guards could argue, we were just acting on orders. We were just following the laws. And then the courts applied different reasonings to put them into trial. One argument was to say, leaving your own country is a basic human right. The East German law was inconsistent with basic human rights standards. And in another trial, the judge concluded, well, leaving the country was a crime, but the use of deadly force was not justifiable. At the end, I think, of the trials, many East Germans were frustrated because the focus was basically on gross violations of human rights. In East Germany, many other crimes had been committed: mass surveillance, spying. But these people were not put on trial, and so the victims were very frustrated. And the leaders, as I said before, they were not fit for trial any longer. And this could also happen in regard to North Korea. So my conclusion is, do not expect too much. And probably the focus should be on the violation of the serious violations of human rights, nothing else. North Korea is also committing many other crimes, like cyber crimes. 10 years ago, we had the cyber hacking of the Nonyeong Bank. The focus should be on the prison camps. That's my personal opinion. Thank you very much. 감사합니다.
권도 교수님이 이제
Yes, Professor Kondo shared with us his insights on the human rights situations in the north, and particularly lessons learned from Germany, his hometown, the Nuremberg trial after World War II, and after the collapse of the Berlin Wall, what kind of trials were underway. And he's also talked about the Auschwitz trial and also the border guard trial. So he has shared with us the various cases of trials that took place and also on what to expect for DPRK. So with the collapse of the regime, what kind of justice should the focus be? And he's also talked about what kind of lessons we can draw upon from the case of Germany. So he has actually given us food for thought and also on where the focus should be. Thank you very much for your intervention. And let us now move on to the last speaker for this session.
Who is there? Now I am honored to introduce Ambassador Paul Sothrak, Distinguished Senior Advisor at the Cambodian Center for Regional Studies and a long-serving advisor to the Cambodian government. Ambassador has held numerous high-level positions, including Cambodia's Minister of Industry, Mines and Energy, Ambassador to Japan, Secretary of State at the Ministry of Foreign Affairs, and Executive Director of the Cambodian Institute for Cooperation and Peace. Drawing on his extensive experience in diplomacy, regional security, and transitional justice, he will present today's talk titled Applying R2P to Crimes Against Humanity in North Korea. Please welcome Ambassador Thothrak.
Thank you very much, Honorable Chair, and greeting again. I wish to thank Mr. Bada Nam again for inviting me. It's a real privilege for me to sit here among the very prominent personality, particularly those who understand international law and serious crime that can be settled through accountability. I will present the view. My background, as introduced, I'm more a political scientist, so I have no legal background. But when I did my master degree in Japan, I wrote a thesis about the tribunal of the mixed court, the Khmer Rouge tribunal. So I know a little bit about this, and I said that Cambodia should invest in justice system to prevent the recurring of the mass atrocity. Anyway, I'm trying to imitate Professor Boris, who's eloquently spoken highly about the pro and con about the justice through the court. Anyway, here's my talk. I'm hoping that it makes sense, but bear in mind, like him, don't expect much, even when I suggest that South Korea should perhaps see if they can use something that Cambodia have done in a mixed court context. So now I'm going to share my view about applying R2P to crime against humanity in North Korea. The concept of the responsibility to protect is not new either to Cambodia and to the Republic of Korea. Both countries support R2P, where the shifting dynamic of state sovereignty, that is to say from privilege to responsibility, as everybody call it, center on the protections of their own population from mass crime, genocide, crime against humanity, war crime, and ethnic cleansing. Now, let me first speak about the commonality between or taken by South Korea and Cambodia when advocating the concept or the norm of R2P. Both South Korea and Cambodia should be complimented for being actively support of R2P. As member of the United Nations, the Republic of Korea joined the global consensus in adopting R2P at the World Summit 2005 in New York, embraced R2P norms and actively advocate the implementations. The ROK also took concrete actions in institutionalizing R2P at the national level, as it is one of the first countries to appoint the national R2P focal point in charge of coordinating atrocity in 2014. Cambodia appointed national focal point in 2016. Beyond the United Nations, Korea scholar, academic, government, affiliate institution also published widely research paper on R2P implementations and its implications for Korea, such as through the Korean Institute for National Reunification and Korean Institute for Criminology and Justice. Moreover, the Republic of Korea is also party to the International Court, Criminal Court, ICC, Rome Statutes in 2002, and has a robust National Human Rights Commission to uphold human rights value and accountability mechanism. For Cambodia, the kingdom engaged with R2P and atrocity prevention is deeply rooted in its own tragic past. I don't think anybody don't know about the Khmer Rouge crime. it happened before R2P was born. So if it happened during that time where there's R2P, I think we may look to R2P to help save more than 2 million people was executed, hard labor, disease, overworks, and so on. Decade after the genocide committed by the Khmer Rouge, Cambodia took a landmark step to establish the Extraordinary Chamber in the Court of Cambodia, ECCC, to prosecute those who most responsible for the atrocity. The ECC was a hybrid court created in 2003 based on an agreement between Cambodia and the United Nations, with the mandate focusing on crime committed by senior leader during Khmer Rouge period. ECCC began its operation in 2006. After 16 years of investigations and trial, 5 individuals were indicted and 3 former leaders were convicted. Well, you hear Professor Boris talk about how many, very small, basically. They were convicted and sentenced to life in prison. In Cambodia, we don't have capital punishment. We cannot execute, there is no death penalty in Cambodia. Those were Pol Pot deputy, his name is Nuon Chea, the Khmer Rouge head of state, Khieu Samphan, and the S-21 prison commander, Kang Gek Iv, who's also known as Dutch. When I did my master, I attended the Dutch tribunal in Phnom Penh. I was in Japan, but I make a trip. Cambodia ratified ICC Rome status in 2002, the first in ASEAN to do so, and established Tuol Sleng Genocide Museum at the S-21 prison for educational and remembrance of atrocity. Recently, in July 2025, 3 important sites such as the M13 Tuol Sleng Genocide Museum and the Jeong-Ah Museum were officially inscribed on the UNESCO World Heritage List. Even the UNESCO, they preserve horrifying places to remember the past, signifying Cambodia's active advocacy in preserving the history and education for the remembrance of the atrocity for the next generation to remember. Furthermore, Cambodia translates its painful experience into regular atrocity prevention by appointing its own national R2P focal point in 2016. It was me, the government of Cambodia appointed me to be the national focal point, and I want to take this opportunity to thank good friends like the Global Center for the Responsibility to Protect Savita was here, Dr. Noel Moralda, and Dr. Saras here from the Asia Pacific Center for R2P, who helped Cambodia a lot, helped my work a lot during those days. Cambodia have even proposed to convene a regional dialogue on R2P, creating a network of R2P focal points across Southeast Asia for collective effort. It never transpired to anything concrete. In other words, ASEAN, the ASEAN, regional bloc called ASEAN have not really buy into the idea. Now let me share some lesson learned, transitional accountability, and suggest how Korea can invest in judicial process to prevent and protect population from atrocity crime, such as in the case of North Korea, and also discuss some challenge that might entail. There's no doubt that applying R2P in the context of North Korea will inevitably be different from Cambodia post-conflict justice process. This is simply because the atrocity in the DPRK are not only ongoing, but its current regime is the one that perpetrated such crime. However, Cambodian experience, in my view, offer valuable lesson for addressing North Korea crime against humanity. this is from the point of view of a political scientist, not from these eminent scholar and expert in international law. I would like to share some of my thought on this aspect as follows. First, justice and atrocity prevention can only be effectively sustained if it is driven by internal community level rather than relying solely on government to mandate the initiative. In the case of Cambodia, the government was able to make such significant progress in bringing about justice and atrocity prevention because the whole populations of Cambodia, anti-war, anti-atrocity sentiment was built through the long history of tragedy or mass crime. Everyone in Cambodia had hated Khmer Rouge. So it's when the government decided to bring the perpetrator to court, everybody volunteered to be witness. So this is, I think, one of the telling story that if you want to do a court case, get the people on the ground to speak about and document what they say much more, rather than just focus on the high-level government statement. For Korea, in the Korean context, achieving sustainable progress, whether in justice, R2P atrocity prevention, or the grave abuse of human rights, will require effort that are not limited to the ministerial level, but also organically rooted in the community effort to do so. This way, despite the change in government, the leader in charge or the political condition that surrounding the state during that time or as it evolved, the commitment for credible justice mechanism will be secure and ensure, meaning it will be inclusive and holistic. It's a little bit humanitarian aspect, but I believe that if you do that, then at the end of the day, the people will be happy. I think the message from Dr. Boris have already mentioned that. Second, the ECC have proven that the hybrid judicial structure between international and domestic judge, lawyers, and staff provide a degree of local ownership while leveraging on international legal expert for multilateral recognition. For Cambodia, the trial will held in Phnom Penh, not a distant foreign venue, allowing the survivor, local and foreign media to cover and translate the event extensively locally. It did not take it to Geneva or The Hague or anything. It happened in Phnom Penh. This is another point. This proximity and visibility help make justice more relevant domestically and strengthen Cambodian legal capacity by working and pairing it with international prosecutor with Cambodian counterpart. This context can also be applied in the Korean Peninsula, in my view, in which hybrid model judicial system that is designed specifically for crime against humanity in North Korea should be encouraged, not only to promote R2P framework, but also to strengthen the ROK proximity and visibility to bring about justice. Thirdly, victim participation, detailed record, and public education was also a distinctive feature and condition for the progress of the ECCC. More than 4,000 Cambodian victims was able to join the proceeding as civil party rather than appearing only as witness, which give them a voice in the process. They provide testimony of suffering, apply for collective reparations, and keep the focus on human impact of the crime. Furthermore, the ECC also helped establish a detailed historical record of the Khmer Rouge era with extensive document as evidence, witness testimony, and verdict, which are all available for future generation in different languages. French, English, and Cambodian language. The court outreach program, such access to information, community forum, and media broadcast brought that information to ordinary Cambodian and international community. Now let me conclude with some suggestion for Korea to develop a hybrid victim-centered judicial system that drive and sustain community-based education and crime against humanity in seeking accountability in North Korea. But I will focus more on the challenge. While there are significant strength and merit toward the ECCC, there are also challenges that Cambodia Hybrid Tribunal face that Korea and the international community should take into consideration on such a framework. I include international community. I think if Korea do it alone without referring to international law, you will have less chance of having a more holistic passing judgment or making sure that people commit crime be properly accounted for. Firstly, the ECC tried only a narrow set of perpetrators in which 5 individuals were indicted in total and only 3 lived to see final judgment. This means that the court selected those most responsible while middle-level officials and local commanders who were also part of the atrocity were not brought to court. I leave it to questions and answer if you want to know why. I will speak more about it. Second, the trial took place many decades after the collapse of Khmer Rouge regime, which delayed justice for Cambodian victims. Many of the accused, such as Khmer Rouge Foreign Minister Ieng Sary and Deputy Noon Chia, died during the process, which made evidence collection harder and passing judgment more restricted or lesser perpetrator. Thirdly, and frankly, the international justice is expensive for taxpayer, and the ECC was no exception. Although we have to thank the international community, Korea included, who helped. Yesterday we have the honorable judge representing Korea in a Khmer Rouge tribunal as well. The ECC operate cost was about 337 million, and it takes 16 years for trial period, which is very high for developing country such as Cambodia. The massive amount of evidence that securing sustainable funding for such an initiative will be vital. There's many times over we have problem with not enough funding to continue the trial, but thank to the international community and thank you to Korea for supporting the court until the end. So let me just simply make a following conclusion. The tragedy of atrocity crime that Cambodia have experienced should never be repeated. The experience from the ECC could be crucial for Seoul to take certain variables into consideration, such as hybrid victim-centered judicial system, the important detailed record, the need for sustainable community-based education and crime against humanity, and the involvement of the international community on atrocity that happened on the Korean Peninsula. You can learn from Cambodia experience, or you don't have to learn, you just take a look and pick and choose what that can be applied to you. Through these mechanisms, Seoul will be better equipped to navigate the road ahead once the opportunity arises to seek accountability for North Korea atrocity in a way that is conducive, fair, and long-lasting. Thank you very much.
Thank you, Ambassador. As we have learned from Cambodia's experience, a victim-centered judicial process, reliable and detailed historical records, and sustained community-based education are essential in addressing grave human rights violations, such as those in North Korea. Given that the Republic of Korea is already a state party to the Rome Statute and is institutionally prepared to concede a hybrid accountability mechanism. Today's presentation is both timely and highly relevant. I look forward to seeing these discussions continue to evolve in a way that contributes meaningful to justice and accountability for the North Korean people. 오늘 네 분의 발표자님들께서
The four speakers for session 6 has shared their insights. And before I open up for questions, there are a couple of comments that I would like to make.
Question to Ambassador and Professor Kondo. There are lots of regional human rights court and human rights commission, except Asia. In Africa, African Human Rights Court, EU Human Rights Court, Caribbean 13 countries, they have their human rights court. Also South America. Is there any plan or our engagement to establish Asian Region Human Rights Commission or Human Rights Court, including R2P advice in ASEAN? Because Ambassador has enough expertise, also Cambodian's national, the history and lots of lessons. How about to propose R2P advice in this region or create a human rights commission or human rights court in the future? When we manage to establish that kind of mechanism, I think North Korean human rights issue and other human rights issues in Asia and the Middle East, we can create a very good foundation, not only to bring the justice or certain measure to punish them, but a kind of a political or regional agenda to make a certain warning or voice to the country or political leaders in this region. Let me listen your wisdom and your thought.
Thank you very much. Very tough question. I will do my best. It is true, there is no law, there is no judicial law. Let's start with the ASEAN first. ASEAN have the OHCHR. You know OHCHR? Dr. Morala here is more eminent than me on this case. You know, we have ASEAN ASEAN proclaim that we take care of a human right. But I have written quite a few articles. I said this, at best ASEAN OHCHR can do is promotion, not protection. Because in today's time, even in ASEAN country, human rights abuse still happen, including in my country. You know, and if you want, there's plenty of evidence, scholarly evidence, written by very renowned people, you know. So I was invited to Kuala Lumpur about a month ago on a dialogue between Australia, New Zealand, and ASEAN on these issues of human rights. And I proposed that ASEAN should set up a court. Set up a court, like you said, what to do. Set up a court, you know, a regional court, and make ASEAN country accountable to it. So, you know, again, like I said, I'm a political scientist. I'm free to say everything. But the state don't like it. And you know why they don't like it. Professor Boris probably can tell you why they don't like it. You know, they don't like it because most of the time, you know who did the violation? Not people in the street. It's the state apparatus themselves. You look at the regime in North Korea. Who did this to all the North Korean people? You think just simple other North Korean people do it to the North Korean people? No, it's a regime themselves. So even with ASEAN, you know, there's no human right law. Make it a law. Korea can take a lead. Invite AP R2P, invite, you know, I'm very happy to have a UN rapporteur. She's have a lot of experience. You should ask her about the Khmer Rouge Tribunal. She spent 10 years in my country. And thank to you, you've done great work, you know. But if you listen carefully to my message, there's still some problem. So anyway, thank you so much for asking me, you know, but, and I call also for, to take responsibility, you need to have the judicial, you know, people like the South China Sea, they talk about COC, politically binding. The only thing you can make things binding is enforcement. You have to put in a law and charge people who violate it using law that they agree. You cannot make statement. You can make all the statement, including you, and very good in making statement. But to change the situation, you need to pass judgment. You need to take it. You have to make the person accountable for their action. And only law can do that. Isn't it true, Dr. Boris? I mean, you ask him. So how to do? So, Chair, I suggest Korea take a lead under APT, you know, ASEAN Plus 3. This will show South Korea soft power. If you can help ASEAN making a law, human right law, that would be good. So thank you very much.
Thank you very much. Professor, you have any comment?
No, it's hard to add anything after the ambassador. I would also think simply there are too many historical differences and understandings. Just take Japan and Korea. There's still no settlement on the comfort women. There's still this dispute, Tokto, Takashima, the naming dispute, and from the outside, it looks apparent that these two countries should work together, that there are so many differences and different historical understandings, and then including the whole region with all these different ideologies, I doubt. I mean, the idea is good, but I think it's probably a good book project. International law, the path not taken, the Asian Regional Court of Human Rights. Thank you very much.
Thank you very much.
Next, I would like to just ask questions to Dr. Cho and Dr. Nam. So the CIO report has looked into the human rights violations of North Korea. There were many efforts for the past 10 years. However, there was no any visible achievements. Most of the focus, I believe, was on criminal justice. So the mechanism was more so focused on the criminal code. However, I think that maybe we do need to establish a Wombier type of law, like in the case of the U.S., that basically enables the country to look into these violations and the victims, whether it be defectors or whoever it may be, through the establishment of domestic law to have way to try the perpetrators to actually pressure the perpetrators, and an asset freeze, for instance, and sanctions. So what I'm saying here is rather than taking on a criminal code type of approach, I think that there could be monetary compensation and other civil avenues to hold individuals accountable. So I would like to ask whether this would also be a plausible solution. So with regard to establishing such domestic law, is there anything that you would like to share with us?
예, 제가 오늘 조금 할 수 있는 것 중심으로 말씀.
So I did talk about what's feasible today, and of course President Kim does ask, isn't A, B, C possible? And I would say, well, legally it would be a bit difficult to achieve. So that's typically my answer, but I know that we're not here to just say that. It's about, so then nevertheless, what can we do? Human rights issues in the North hasn't been resolved. It's still quite grave and serious. So we cannot just say that it's not possible. We have to think about then what is possible. This, I think, and these sessions are about what we can do rather than what we cannot. So legally and judicially, it's not a easy journey, and I think that that's why we're here together to gather our wisdom and ideas. And especially with Trump 2.0, we're seeing bifurcation. We're seeing very difficult domestic political situations. So as an international law scholar, and also with regard to multilateralism and during the G20, it was emphasized all the more. However, we do see the key actors no longer part of the platform. So every time during lectures, I say that a crisis is an opportunity. And I always say that it's now high time because it's been the biggest crisis, meaning that we now have the biggest opportunity at hand. So what you've said was in the US or UK and EU, they have the Sanctions Act and other regulations that were introduced. And whether it be in the region or within the country, there are sanctions lists where individuals and entities will be sanctioned. And if that asset is not in that country and you have no plan to travel, then this will be obsolete. But basically, it's a type of signal. It's a type of warning. And I think that Korea can do something like that, but I don't think that it will happen right now. Are we not sanctioning? But yes, we are. So UN sanctions we do enforce and we do execute. So the sanctions by the UNSC towards the north, yes, we do execute, but that has to do with sanctions on the North Korean nuclear program. But there are no sanctions when it comes to North Korean human rights issues. The UK, the US, and EU have unilateral sanctions, which includes both the nuclear program as well as the human rights violations. So what you're saying right now is that irrespective of the UN sanctions, is there anything unilaterally we can do against the perpetrators of human rights violations? Why don't we put together a domestic law? So that's how I understood your question. And of course, if there's will, it can be possible. It can be done. But realistically, the legislative branch would have to agree. And this idea in the US and EU and UK, if they can do it, we can say, I mean, there's no reason why it cannot be done here. So constitution has to do with, well, domestic affairs as well. So I can say that nothing cannot be done. It's not impossible, but I think that we have to think about it. And then there are, of course, various compensation lawsuits and litigations on, well, prisoners of war, for instance. So, of course, you need the funding and the assets to compensate, and that makes it a bit difficult. But at any rate, there are litigations run by Hanbyeon and a number of organizations. And I think that whatever the cards it may be, we need to play the cards if it may provide us with a solution. So rather than saying what cannot be done and what can be done, I think that it's about understanding what can be done, bring this all together, and put in the efforts all together, because as long as violations still do exist, we have to do whatever we can. So in that aspect, I think that it's also worthy to take some effort to do something like what you've suggested.
네, 감사합니다.
Thank you very much. I think the article response has been presented already by Professor Cho. Let me respond in the Korean language. At the United Nations level, as we speak, and as I said earlier, the Special Rapporteur assignment is engaged in the various ways to exert, saying that we need to engage in various ways to exert the pressure on North Korea. We should induce them to come to the table for dialogue and also think about the holding them accountable. So this is like a two-track approach that is desirable as an appropriate measure. So we need to continue to monitor the platform based on the domestic legal frameworks as well. At the United Nations, South Korea is in the close proximity to North Korea. So Korea is in a great location to be able to collect evidence for holding North Korea accountable later. So and Korea is therefore located in a very convenient location in that regard. But the willingness of the South Korean government to carry out such a role is something that remains to be seen. About the criminal justice, we talk about universal jurisdiction. Many countries talk about exercising universal jurisdiction. But I understand that Korea does not exercise universal jurisdiction yet. And when it comes to holding jurisdiction, having jurisdiction over individuals of North Korea, we are still waiting for the legal community to come up with a clear position on that. On the civil proceedings, there have been a few cases, but how we secure the compensation that is ruled by the court is another matter. There are many difficulties that still remain, and that means we have a lot of challenges to overcome, but we need to continue the monitoring and studying all these different ways. Thank you very much. Now I'd like to open the floor for the Q&A sessions. If you have any question to any of the four presenters, you're welcome to ask a question. Yes, please go ahead, and please make sure the microphone is delivered. Good afternoon. My name is Victor Jang, and affiliated Justice for North Korea. I have a question for Professor Boris Kondo.
So, your presentation yesterday was quite inspiring, and in the last part of your presentation, I do recall that you've talked about the Genocide Convention and that North Korea is not enforcing this convention. So whether it be the punishment and especially with regard to the various violations in the political prison camps that are still taking place. So based on international law, with regard to trying DPRK, we do see the veto from the permanent members of the UNSC, and I think that you've mentioned that there could be some way that we can do about this. And also, I recall Professor Lee Yang-hee did say something similar. So I just want to clarify the permanent members. So basically, we're talking about Russia and China. So how can we find a way to limit their veto powers? Is it possible? Can you maybe clarify that point once again?
Yesterday, what I tried to explain is, in general, the Security Council enjoys a wide margin of discretion when and how to act. And the system itself, I think, is also quite good, because it prevents that the permanent members are taking measures against each other. And also in a given situation, it might be also very difficult to find a solution. And then we have the problem of mass atrocities. And what I said yesterday is there is no rule of customary international law, there is no treaty on crimes against humanity saying that the permanent members of the Security Council cannot use their veto power in case of mass atrocities. How could that be changed? Probably through an agreement. And the UN Charter itself can be also changed. I think there has to be a 2/3 majority in the General Assembly, and the permanent members should not veto this approach. So I think if the permanent members agree, in case of mass atrocities, we cannot use our veto, I think this would be a possibility, but very unlikely from everything, I think, what we know from China, from Russia, and probably the United States would be also not very much interested, because the countries using the veto in the Council are these three countries. It's not France or the United Kingdom. I hope I can satisfy you with my answer. Yeah, limit it. I think if they are agreeing on a process in the General Assembly and say we are changing the United Nations Charter as an additional article, that the veto power cannot be used in case of mass atrocities. But that's unlikely, because that would require that the permanent members of the Council give their consent. Maybe my colleagues here at the table, Sang-Yong, or anyone else, maybe if you want, please add something to it.
예, the power to exercise veto power by the UN permanent members of the Security Council, yeah, if the charter is amended, it is impossible, and to amend the charter, you know, the veto power also should apply again. And so currently, very, very not easy, seemingly. But anyway, just before the outbreak of the Ukrainian war, the General Assembly tried to adjust some improper use of veto power by the permanent members. It is it opened the new procedure to explain the reason why the permanent members used the veto power in the previous case as Security Council. So in some cases, the permanent members who used the veto power attended the General Assembly and explained why they used that power. It's just a procedural requirement, not legal obligation, but anyway, the permanent members followed the UN General Assembly's resolution. But anyway, just after that procedural effort, the Ukrainian war broke out. So after then, many efforts seemingly to go. So very difficult situation. But anyway, there are so many efforts, and still we will should make all efforts to how to amend the current system, because unless we just give up the UN system, but we will try further. Yeah.
예, 다른 플로어 질문 계시면은 받겠습니다.
We open the floor once again for a Q&A session. Please raise your hand. Well, so it's been about 2 hours already since we began the afternoon session. It's been a very lengthy conference beginning yesterday, stretching for 2 days. Yes, we have someone at the back, gentleman at the back.
Hello, Professor Kondo. My name is Choi, and I work with a North Korean human rights NGO. I would like to ask you a question. While there is no dispute that border shootings, torture, and political repression were already prohibited as international crimes, at the time, the European Court of Human Rights 2001 East German cases make foreseeability the key criterion for individual criminal responsibility. In the context of North Korea's highly closed, indoctrinated, and coercive system, do you believe that low-ranking soldiers or operatives could restrictively have foreseen the unlawfulness of their actions And if such foreseeability cannot reasonably be demanded, what form of the individual accountability or transitional justice model do you consider most legitimate and practical for these lower level perpetrators? Thank you.
Did I understand you correctly? Should there be accountability for low-level perpetrators? Is that what you're saying?
이 질문을 한 번 더 다시
Yes, could you once again repeat your question, and please take it one by one. If you can speak slowly, that would work.
방금 질문하신 분.
Yes, so can you repeat your question once again? Can you clarify your question so that Professor Kondo can answer the question?
I'll say in Korean. 안녕하세요, 교수님.
Yes, Professor, I currently work for a North Korean human rights NGO. I am Jae-Hoon. I have a question for you. So with regard to torture, political persecution, and what happens in the border, it's true that according to international law, it's a violation. However, with regard to East Germany, I think that you've mentioned about 2001 at the EU Human Rights Court, where it had to do with predictability. But then if you look at DPRK, it's a closed regime, and it's coercive, and there is a strong brainwashing of ideology. So then in the case of the lower ranking soldiers, they're not those that make the decisions. They're just the result of the system. And in many cases, they do not understand that what they're doing is illegal. Do you think there was predictability for the soldiers to understand that this was unjust and illegal? So if we ask for predictability on their side as well, then for these soldiers, what kind of individual accountability can we actually ask of them, and what kind of transitional justice would actually work for these lower ranking soldiers?
That sounds more like a philosophical question to me. Is it not obvious that someone who is leaving the border should not be killed even if it's illegal to leave the border? And whoever is a soldier or policeman, I think this year we had the case in Nepal. Young students went to the streets and they called an end to corruption, and some of these young students got shot to death, so they got killed. And I think the policemen should have a general understanding this certain use of force is out of proportion, irrespectively of any legal limitations whatsoever.
Can I share the view? Because, look at the Khmer Rouge Tribunal. Only the top leader are tried. The debate among Cambodians, including myself, why not the low ranking being tried? Why not? Now, because the decision to have the mixed court is a political decision. So the low ranking have no political power. So if you want to charge down below, you need to break the barrier. You have to make sure first you make the top accountable. I can tell you even a more frank opinion. During the Khmer Rouge, you know which country helped the Khmer Rouge the most? Do you know? China. If you don't know now, you know. Okay? So China never want Khmer Rouge leader to be tried. But at the same time, the American dropped a lot of bomb in Cambodia, secret mission. The American also don't want. You see, this you deal with big power. Unfortunately, in North Korea, you deal with the nuclear program of Kim Jong-Un. Right now, it's a nuclear power that he have. So lower ranking can only, in my view, can only be accountable if the system of justice that you're going to apply is also free to apply from top down, bottom up. At the moment, like Professor was talking about, there is a misunderstanding. Duterte is another one who ordered, give a license to kill to the police that clamped down the drug. He allowed the policemen in Philippines to shoot. And that's why now he's in custody, not yet charged, but the policemen are not yet charged in the Philippines. So it's you see this, to me this is a double standard in the international system. And we can fix it if Korea want to take a lead. You know, like this one, the question that you asked, this gentleman asked about, I think it's time that small state, middle power like Korea, be bold enough to say, we cannot leave our future to the big guy, the big five all the time. Something must be changed. Start with genocide. Propose, seek signature of support. The UN system is, every member of the UN system have the right to change the UN system work. How did it work? Do you exercise that right yet? In my opinion, you don't exercise that because you're very afraid of the big guy. Including Cambodia, we're very afraid of big guy. So, but I think if we have big brother like South Korea who take a lead, maybe we join you. So let's do something. You know, maybe Mr. Bada can write a motion from here that we seek the UN Perm 5 to not to use veto in genocide. There's no harm. If they don't agree, they don't put you in jail. It's okay. They throw away. But at least you make your voice heard. Do we have the courage to do it? I encourage you to do it. I will sign with you.
예, 그러시면은 추가 질문 없으시면.
Yes, thank you. If there are no further questions or comments, I think that we can end the session here. Thank you. But this may be at a slightly different angle, but we do need to refer to the unification case of Germany, and also we did seek the ruling of the Hybrid Court of Cambodia, which actually offers us with a lot of lessons, so that also should be taken into consideration. So with regard to German reunification, what we do need to understand is that, as you know, at the time, in 1998, it was before the Rome Statute, so it's 98, and right now we are now dealing with crimes against humanity, and we now have the ICC and the relevant Rome Statute, and as a state party, all of the relevant norms are currently being enforced. So if you think about what it was like back then during the unification of Germany, and as we talk about these international crime of DPRK, that is probably the biggest difference of the existence of the Rome Statute and the ICC, whether it did exist or whether it did not. So we need to take this into consideration when we compare. Just because it's unification, we cannot think of this as an apples to apples comparison, because it was under a different circumstance and it was under different mechanisms. And also in the case of Cambodia, was successfully launched the ECCC. But of course, we heard from the ambassador both the pros and cons and the balanced view. So right now it may seem impossible, but one day when we do get unified, I think that with regard to the crime of DPRK, of course, we can go back to colonial rule by Japan, and there's also the Korean War. So in terms of transitional justice, there are so many things that we do need to resolve on, and especially during military dictatorship, there were things that we can do on the South, but there are also things that have to do with inter-Korea. There's also Korea-Japan issues, and if this unification is led by the South, then with regard to human rights violations of the DPRK, there's also things that we need to try and put to justice. So in terms of transitional justice, at least for the higher-ranking officials, when it comes to impunity, that should not be the case. That should not be upheld. I think that there is that consensus there that impunity should not be offered to the higher-ranking officials. Of course, it may not be an obligation under the international law, but if we look at the trending of the criminal law, I've mentioned if somebody does file this case, the prosecutor can actually lead to a criminal litigation. And then based on principle of complementary, if it's not done by the domestic court, it can be done by the international court. So after reunification, if necessary, all of the, let's say, party members, we can of course not, indict each and every one of all of these individuals, but for the key members, whichever method it may be, I think that we do need to have them be tried, which befits the definition of justice. But in terms of the scope, that's a very difficult question to answer. So it has to be, of course, desirable. It has to be future-oriented. We have to first seek into the combination of both past and future. There's, of course, consensus necessary amongst the people, and we need to put together all of the information, the testimonies by the victims, and really set the right scope. And in terms of the specific method, would it be referral to ICC, or just like the Cambodia case, it may be very costly because we have to build a new court. Would it be a hybrid court? Or then would it be via a criminal litigation under the domestic court, to simply put? So for us, it may be simple, but then would this be justified internationally, or do we have the expertise to do that? So it depends how we should do about this. This is something that we have to prepare in advance so that we can actually choose from the options that are available. If we're not prepared right now and to say that we'll do it and deal with this later, that's not the right choice. I think that it's about being prepared for all options and then make the decision when that time comes. Exactly, I don't know what that would be. But at any rate, there were a lot of comparative studies. We've looked into a number of cases, a number of countries. But I think that there are things that we can refer to, but then there are also areas that are completely different from these other countries. So in terms of how we can actually deal with this, we do need to prepare way in advance. And once that window of opportunity opens, I think that that's when we should choose the most desirable option. Thank you.
Thank you to all our presenters and to the audience for such thoughtful engagement. What we heard today underscores several themes that deserve continued attention. The importance of community-based participation, the potential of hybrid judicial models, the need for preserving detailed records, and the role of public education in preventing denial. While the situation on the Korean Peninsula presents unique challenges, the comparative insights shared today remind us that preparedness, both legal and societal, is essential. The pursuit of justice is not a single event, but a long-term commitment requiring political will, regional cooperation, and international support. With that, I would like to thank our speakers once again for their significant contributions, and I encourage all participants to continue the dialogue as we move forward in this conference. Thank you very much.
with this concluding discussion on accountability, including transitional justice, the core of the North Korean human rights issue, we bring this two-day international conference to a close. I'd like to express my sincere gratitude to Judge Park Sung-gi and all the panelists for their valuable contributions. My deep appreciation also goes to everyone who worked to ensure this successful completion of this important conference marking the 20th anniversary of R2P. I'm especially grateful to our distinguished guests who have honored us with their presence from afar. Ms. Sevita Pandey, Dr. Sarah Tate, Ambassador Soshira, Dr. Noel. Thank you once again. Now, as we conclude this event, and with the consent of all co-organizing organizations, GCR2P, APR2P, NKHRC, PSCORE, Hanbyun, and also other participants, I will proceed to present the joint statement in lieu of formal closing remarks. We gathered here in Seoul to commemorate the 20th anniversary of the unanimous adoption of the R2P principle at the UN World Summit, and to mark over a decade since the 2014 UN Commission of Inquiry report defined the actions of the North Korean regime as crimes against humanity. Through the discussion of the past 2 days, we expressed deep concern that despite R2P establishing itself as an international norm, mass atrocity crimes continue to be perpetuated in North Korea. And around the world, we reaffirm that North Korean regime has not only manifestly failed to protect its own population, but is actively continuing systematic, widespread, and gross human rights violations as a matter of state policy. Therefore, the human rights experts, legal scholars, civil society representatives, and policymakers participating in this conference declare the following. First, condemnation of the persistence and the escalation of crimes against humanity in the DPRK. We confirm that the human rights situation in North Korea has worsened over the past decade. The intensified control of information through laws such as the reactionary ideology and cultural law, the shift towards clandestine, non-public executions, the continued operation of political prison camps, and the exploitation of overseas workers like modern-day slavery constitutes clear crimes against humanity. Furthermore, we strongly condemn the reality where the regime pushes its own citizens into an illegal war of aggression through military cooperation with Russia. Second, call for judicial justice and accountability. There is no lasting peace without justice. We agree that accountability must not be abandoned despite the structural paralysis of the UN Security Council. We urge the UN General Assembly and member states to explore all possible judicial alternatives, including referral to the ICC to hold North Korean human rights violators accountable. National courts must actively exercise universal jurisdiction and other mechanisms to send a clear message to perpetrators of human rights abuses that there is no safe haven. Third, victim-centered approach and protection of refugees. The core of R2P is protecting people, not state. We strongly urge all countries, including China, to strictly adhere to the principle of non-refoulement. North Korean escapees are not illegal migrants, but refugees fleeing for survival. Forced repatriation is an act of aiding and abetting murder, leading to torture and execution. In particular, we note the recent case of 2 North Korean soldiers detained in Ukraine who have expressed a strong desire to defect to the Republic of Korea. Under the absolute principle of non-refoulement, the Geneva Convention and international law, they must not be repatriated against their will. We urge the South Korean government and the international community to take immediate protective measures to facilitate their safe settlement in South Korea. Restoring the right to health for North Korean women, children, and persons with disabilities is the starting point for human rights restoration. We demand a transparent system where humanitarian aid, including maternal and child health, reaches the most vulnerable regardless of the political situation. Fourth, applying R2P to new threats. We recognize the severe threats to human rights posed not only by traditional atrocity crimes, but also by the climate crisis, surveillance, and control powered by AI, and cyber attacks. The international community must expand the scope of R2P and respond preemptively to ensure these new threats do not become another form of violence, destroying the survival of specific groups. Fifth, concrete recommendation for action to ensure that slogan, "Never again," does not remain an empty promise. We call for the following actions. First, to the UN and the international community, the UN General Assembly must utilize the Uniting for Peace resolution to take collective action on North Korean human rights when the Security Council fails to function. Second, to the ROK National Assembly, the North Korean Human Rights Foundation, which has been drifting for 9 years, must be launched immediately to fulfill the legal and institutional responsibilities for improving North Korean human rights. Third, expanding information access. International support for the inflow of outside information and the truth offensive must be significantly strengthened so that North Korean residents can awaken to their own rights. Next, strengthening solidarity. We must build an Asian human rights solidarity in cooperation with civil society in Myanmar, Cambodia, and across the region to resist state violence and protect the victims. Conclusion. We firmly reject the North Korean regime's anti-unification and anti-peace hostile two-state doctrine and affirm that democratic, peaceful unification of the Korean Peninsula, where freedom and human rights are guaranteed, is the ultimate solution for protecting North Korean residents. We solemnly pledge to continue our actions until the day North Korean people regain their freedom and dignity, and until true peace based on human rights is established on the Korean Peninsula. November 26, 2025, participants of the International Conference on the 10th anniversary of R2P and North Korean human rights, including GCR2P, APR2P, NKHRC, PSCORE, Hanbyeon. Thank you very much.
Thank you to PSCORE's President, Attorney Kim Tae-Hoon, for those closing remarks. This concludes this year's session on North Korean human rights and the responsibility to protect. We thank everyone for attending and joining us in those insightful discussions. And we hope everybody took something from those discussions. Before everybody leaves, please remember to hand in the translation devices to our reception desk. And also please remember to scan the QR code on the posters and fill out our questionnaire for the satisfaction survey. Thank you again for your cooperation, and have a safe journey home. Thank you.